May you please, your lordship? Lordship, I beg to mention for item number 33. There is some difficulty on the part of the petitioner. Kindly mention.
You see, there's a division bench sitting.
Sorry.
Item 1 for hearing.
May it please your lordship. So the other day, lordship, I have done a part of my submission on arguments. The other day, I basically highlighted the prayer portion of the petitioners. Then I have taken your lordship to the second accord, various clauses. Then I have also placed some clauses of the third accord and the notification of 28 September 2020. And I basically mentioned on one legal submission that the petition is premature in nature. That was my submission. And I have also made a submission that the role played by the petitioners at various points of time. And I would like to start that part again by taking your lordships to paragraph 6 of the PIL at page 38. What I am trying to project in my overall submission on the basis of various facts is that this is purely a politically motivated petition. Page 38. Two groups of people had entered into the accord at various points of time. Now, one set of people are not happy with the subsequent accord. This is what they have highlighted and which I am trying to place it from their own pleadings. Lordship will kindly come to page 38, paragraph 6. The petitioner number 1 is a Sahitya Academy recognized non-political organization, was formed on 17 March 1985 with the aims and objective to give scope of literary work to the Bodo writers and create new writers among Bodo community. So I have nothing to say on this, Lordship. This is correct like the Assam Sahitya Sabha. This is another organization. Now, petitioner number 2. Petitioner number 2 is one of the signatories of the first Bodo Accord signed in 1993. So, petitioner was number 2 is directly involved with that process of bringing peace to Bodoland. So, he was, petitioner number 2 is one of the signatories to the first Bodo Accord signed in 1993. He has been a 4-time elected member of parliament. The petitioner number 3 has been a 3-term cabinet minister in the Assam government and one of the signatories of the second Bodo Accord. That is why I am trying to emphasize that this is a politically motivated petition. Petitioner number 4 is the former deputy chief of Bodoland Territorial Council from 2003 to 2020. He is an integral part of the earlier regime of for 3 consecutive terms in BTC and one of the signatories of the second Bodo Accord. So he was also one of the signatories of the second Bodo Accord. Petitioner number 5 to 9 are all public spirited persons and signatories of the second Bodo Accord. The petitioner number 10 to 95 are all vigilant, public spirited and conscious citizens of India residing in BTC. As such, they are entitled to all the rights, privileges and protections guaranteed to the citizen of India under the Constitution of India and the laws framed thereunder. So a major chunk of the petitioners are all hardcore, deeply involved political personalities, and they were part of the same process of negotiation, discussion, and signing of accords and implementation of accords from 1993 onwards till 2020, till they've gone to the opposition side because they lost the democratically held election. Now, what they are trying to compare? They are trying to compare the first accord, second accord, vis-a-vis the third accord. In first accord, there was an act subsequently from 1993 to 2003. It was not a sixth schedule area. It was subsequently in second accord. The area was brought under sixth schedule, and there was subsequently amendment to the sixth schedule, and a constitutional amendment had taken place in the month of September 2023, 2003. So the whole area became a sixth schedule area from 2003 onwards. BTC was formed. From 1993 to 2003, there was a act, state act, and which was repealed after the 2003 second accord was signed. So the earlier state law was repealed. So the first 1993 accord resulted in formation of BTC, and there was an enactment of a law, state law, BTC. BAC, Bodoland Autonomous Council. Then 2003, that act was repealed, and that administrative area was diluted, and a new concept came in after the signing of the second accord. That continued up to 2020 till 27th of January 2020, when the third accord was born. Now, paragraph 7 now. Respondent number 1 and 2 were signatories to the impugned third Borough Accord. 1 and 2 are the central government and the state government. The respondent number 3 is the committee that has been constituted by notification dated 28/9/2020 under paragraph 14 of the sixth schedule of the constitution of alteration of area in BTAD in pursuance of clause 3(1) of the MOS dated 27 January 2020. Now, coming to the facts of the case, this is important because there is no quarrel about the factual aspect, which they have correctly stated. So let us see what was the factual development in BTC. Page 40, paragraph 8A. The government of India, with a view to stop the violence and restore normalcy and bring about an amicable solution to the problems of the Boro people, held a series of meetings with the government of Assam as well as with the leaders of Boro, All Boro Students Union and Boro People's Action Committee, which finally culminated in signing of the Bodo Accord on 22/1993, first Boro Accord. The basic objective of the accord were to provide maximum autonomy within the framework of the Constitution to Bodos for social, economic, educational, and ethnic and cultural advancement. The Bodoland Autonomous Council Bill was introduced in the Assam State Assembly on 5th of April 1993, and the bill was enacted as Bodoland Autonomous Council Act 1993. It provided for the establishment of Bodoland Autonomous Council within the state of Assam with maximum autonomy within the framework of the Constitution of India. The 1999 witnessed India at war with Pakistan over Kargil to facilitate the movement of the Indian troops stationed in Bodoland to the nation northwestern border. In view of Kargil, the BLT was only underground outfield of the northeast to declare unilateral ceasefire again during the period so that the country's sovereignty is protected. In response to the ceasefire declared by BLT, the government initiated informal talks and on 15/3/2000 declared a ceasefire from its side. On 1/5/2000, formal tripartite talks involving Government of India, Government of Assam, and the BLT commenced. On 10/2/2003, the Government of India held final talks with the major Boro groups like APSU, BSS, BPAC, and all the elected representatives of both State Assembly as well as the Member of Parliament. And after obtaining their consents, the Government of India and the Government of Assam went ahead and signed the Memorandum of Settlement with the Bodo Liberation Tigers, BLT. Second Boro Accord. The Memorandum of Settlement was arrived at by taking into confidence all sections of the Bodo society as well as other cross-sections of the society as well, who had unequivocally expressed their support to the same. A copy of the Bodo Accord is annexed. The main objective of the second Bodo Accord was to create an autonomous self-governing body to be known as Bodoland Council, Territorial Council within the state of Assam, and to administer a territory spanning 30979 villages, making 4 co-terminus district, Kokrajhar, Chirang, Baska, and Udalguri under the provisions of 6th Schedule of the Constitution of India. The Bodoland Autonomous Council Act 1993 was repealed by the Assam Legislative Assembly on 4/4/2003 following the signing of the Second Bodo Accord. Pursuant to the Second Bodo Accord, the provisions of the 6th Schedule to the Constitution was amended by the 6th Schedule to the Constitution Amendment Act 2003 on 8/9/2003. So, my Lordship may be pleased to pause here for a moment. The accord was signed in the month of February. At that point of time, there was no constitutional amendment. Whatever was inserted in the accord, subsequently the Parliament ratified it and made the necessary changes in the Constitution in respect of the 6th Schedule. That act also they have amended, annexed in the here. Why I am saying here, the present act has also been signed and certain things has to be done. Once that is done, then the constitutional amendment has to take place. If there is a change of the boundary, for example, then a ratification will be required and the amendment will be required. That is why my submission is that it is a premature case. The accord has been signed, the committee has been formed, the committee is entrusted with the job of taking opinion from various groups of people, whether they want any change of the territorial boundary of the BTC area or not, whether some additional village should be included, whether some village can be excluded because of the population pattern may not be as per the 6th Schedule norms. All these things are open. Once that exercise is completed, it has to be followed by a constitution amendment. Till that time, it cannot be implemented. That stays, that cause of action as of now has not arisen till now. May I continue further? Pursuant to the second accord, the provisions of the 6th Schedule was amended to so and so on 8/9/2003. That the government of Assam by notification dated 31/10/2003 adopted and approved the MOS 10/2/2003 and resolved to extend the executive powers to 40 subjects department annexed in the accord of Annexure 3 of the accord. Now, coming to next. Pursuant to the consultation held with the BTC authorities, the Welfare of Plain Tribes and Backward Classes Department, Government of Assam dated 16/10/2004, laying down the administrative procedure and modalities for the purpose of day-to-day administration in the BTC area in respect of 39 subjects department transferred. So at that point of time, which department of the Government of Assam was dealing with the affairs of BTC, which they were at the helm of power? Welfare of Plain Tribes and Backward Classes Department. That department was handling, that was the administrative department of the Government of Assam, because funds has to go from the state of Assam to BTC. Funds will also come from the central government. It has to be routed to a department. Straightway, it cannot be given. And that there is a role of the Honorable Governor also. Instead of this now, what is the department now? Welfare of Plain Tribes and Backward Classes Department. It is a general department. It caters the need of all the backward classes and plain tribes of the state. Not only it is BTC exclusive department. Under the new act, a separate BTC department has been created. What is wrong? It is the call of the administration. It cannot violate any constitutional. Earlier, there was a department which was handling the general affairs of all the plain tribes and backward classes of the state. It covers the entire state, whether it is a 6th Schedule area of BTC, Dima Hasao, Karbi Anglong, or rest of the state of Assam. But now a separate department has been entrusted to look into it, and they are aggrieved by that also. Going further, K. The BPF, Bodo People's Front, comprising of the erstwhile BLT members, was formed as a political party in 2005. After the general election 13 May 2005 and subsequent by-election in November 2005, the 40 members Legislative Council had been formed to look after the development work in the Bodoland Territorial area districts. The remaining 6 members were nominated by the governor from the unrepresented communities. Thus, there are altogether 46 members of the council representing all communities of BTC area known as members of Council Legislative Assembly. BPF formed the first elected executive territorial council after the end of the election. They remained in power for 3 consecutive terms till 2020. What I am trying to emphasize from here is that PPF was the organization which entered into an agreement with the central government and state government. In the third accord, they were witness and they were at the helm of affairs, BPF. Here, another party was there, 2 parties, in fact, NDFB, 3 factions, then another Borough organization, plus the APSU, all Assam Borough students. After the third accord, they form a political party, UPPL, and they won the election. That is why it is an entirely out and out, a political exercise, political affair between 2 groups. Tomorrow there can be another group also. We do not know in future. But whether all these political activities, when it is the game of the ballots in a democratic polity, whether the court has any role. They have done the same thing for 15 years and they proudly say that we are at the helm of affairs from 2005 to 2020. Now they are out of power and they have filed this petition saying that the area will change. Earlier, there was a fixed number of villages. There can be additional few villages also now. That option is open. Instead of a department which was handling a general active affairs of all the plain tribes and backward classes of the state, a separate department exclusively for BTC has been created. Whether are these unconstitutional affairs? When you say it is fine, fine. When the other people do it, then they find fault. It has to be tested on the touchstone of the constitutional mandate. What provisions we have violated, whether it is the central government, whether it is the state government, or whether it is the BTC regime at power now. My humble submission is that there is absolutely no constitutional violation. I will go one by one. They are saying that a violation of Article 14. They are saying a violation of Article 25. They are saying a violation of Article 29. They are saying violation of Article 21 also. But they have to demonstrate it. And all their recordings I have seen, Lordship, I could not find what exactly the constitutional violation had taken place in this present affair. Writing the things is very simple. There is a competition between 2 accords now. If I go through the whole petition, whether the second accord was better or the third accord is better for the people of Bodoral, and who will take the call? Not these people, individual persons from 10 to 95 or something. Ultimately, for any kind of decisions involving public, it is the elected representative who have to take the call. In parliamentary democracy, Lordship, every individual's opinion culminates through the process of election and there is a public representative. Guwahati is a Lok Sabha constituency. So the local MP will represent the opinion of all the people. I may differ with the opinion expressed by the MP, but it will be considered as the opinion of all the citizens of Guwahati. There are 13 lakhs people in this constituency. Every person can have their own personal opinion. But whoever has the majority of the opinion, that will prevail under the system. Otherwise, the system will fall. It will not run. We must have a workable system. These 95 persons, additionally, they may have their exclusive personal opinion. There is no doubt about that. And if any private right is affected or aggrieved by any private or individual right has been infringed by this action, PIL is not the forum. They can go to the writ court under 226. According to them, one of the grievances is that the committee which has been constituted under the terms of the accord, their representatives are not included. They can very well go to the writ court for that, not before this PIL, because that committee has been constituted as per the norms set in the third accord. So if anybody wants that, I should have got that opportunity of becoming a member of that committee. My personal right has been violated, not public right. In that case, 226 court single judge, not a division bench, under the norms of the High Court rules. In PIL, private right may not be infringed. But whatever committee has been constituted, it was as per the norms set in the accord. So there is no violation. In fact, a more person could have been inducted, Lordship. That would have been in a different area of exercise, judicial scrutiny, not in a PIL like this. Now, coming further, then page 46, going ahead, sorry. A tripartite accord, third Bodo Accord, was signed on 27 January 2020 by representatives of some Bodo organizations with the central and the Assam government. This accord presents a new model of power sharing and governance in Assam under the 6th schedule of the Indian Constitution, which is quite detrimental to the interest and welfare of the Bodo people. The Bodo parties to the agreement, including all Bodo Students' Union, the United Bodo People's Organization, UBPO, and all the 4 factions of NDFB, a copy of the accord is annexed. So, various Bodo area representatives from various entities were part of the signing of the accord. Then, several citizens and organizations have since written to the government opposing the latest accord, highlighting their apprehension. As a matter of illustration, 2 of the many representatives have annexed to this bill. However, no response has been received till date from the respondent authority. If a representation has been submitted and it has not been acted upon, whether a PIL can again come up for their private grievance. Because the representatives of Bodoland area, all Bodo Students' Union, United Bodo People's Organization, 4 factions of NDFB, plus the BPF, who are the earlier signatories, they were part of that exercise. Their signatures also appear. If Lordship is pleased to look at the third accord, who are the signatories there? Page 159. Page 159, Lawrence Isleary, General Secretary, APSU, Pramod Boro, President, APSU. Now they have formed the political party UPPL, and Pramod Boro has become the Chief Executive Member, CEM, of BTC or BTAD now. Next page, Ranjan Doimari, NDFB, Govinda Busumari, NDFB, B. Sorgiari, NDFB, and Dhirendra Boro or NDFB. There are various factions of NDFB. Everybody has joined in. Then Mihineshwar Busumotari, President, UBPO, United Bodo People's Organization. Then on behalf of Government of Assam, BTC Chief Secretary Kumar Sanjay Krishna, and on behalf of the central government, Satyendra Garg, Joint Secretary, Annie MHA, Ministry of Home Affairs, representing the central government. Signing of this agreement is witnessed by who are the persons present there. The CEM of BTC, Hagrama Mohilari. He represents Bodoland People's Front, BPF. So without his consent, it cannot have been done at that point of time. So all the persons who are representing the petitioner side now, from 1 to 9, their leader is CEM BTC at that point of time, Hagrama Mohilari. The second in command are before this honorable court. The first in command is not before this honorable court. So the persons whose leader is Hagrama Mohilari signed this, witnessed this accord signing of an accord has to be witnessed by somebody. And who are the other persons witnessed it? Sarbananda Sonowal, CM Assam, and Hemanta Biswa, Cabinet Minister Assam. They have all witnessed it. So my humble submission is that when they say that all the people of Bodoland are not happy with the signing of this MOU on 27th of January 2020, it may not be a correct statement at all. All these parties, EPSU, UBPO, NDFP, then erstwhile BLP and their subsequent political entity that is called BPF, they are all part of this exercise. Who is left out? When the leader is there, present at the signing, without any objection, his subordinates, the second in command and the rest of the same political party. That is why my humble submission is that this is purely a politically motivated petition. Now, page 53. They first went to the Supreme Court and Supreme Court said that they can come to the Honorable High Court. Pursuant to the aforesaid order, the petitioners herein in a meeting held on 9/11/2021 unanimously resolved to file a writ petition, public interest litigation under 226. In the middle, it was further resolved to authorize petitioner number 2 herein to sign the affidavit on behalf of the petitioners. Absolutely no difficulty on this. Only thing is that they all belong to, they have a political color. Now, what are the grounds they have challenged? Although they have argued many things. Federalism is one, taking away the rights of the page 78, grounds of challenge. Page 79A. This is very important. I was submitting that there is a competition between second accord and third accord. That is the competition. For that memorandum of settlement, third accord signed on 27 January 2020 between the Union Government of India and the State Government of Assam on the one hand, and the leaders of EPSU, UBPO, NDFP, 4 factions on the other, runs contrary and against the spirit of second Bodo Accord signed on 10/2/2003. So their own submission, their own ground. That third accord is it is worse than the second accord. This is their contention. It runs against the spirit of the second accord signed on 10th February 2003. It may be noted that unlike the latest MOS, the second accord was arrived at after an extensive consultation and threadbare discussion with all the stakeholders, and thus it received widespread acceptance. The impugned MOS defeats the purpose of the second accord and virtually renders it ineffective and redundant. The impugned clauses are unworkable and vague. They have to explain it before this Honorable Court, how it is unworkable. But unworkable or workable, that has to go through a time of testing. It is not that our constitution has been amended so many times, 103 times till date. This accord also 93, 2003 and 2020. There are changes, evolvement, the growth of the society, the dynamics changes. So there can be changes, but whether those changes can be accepted or not, it has to be tested against the principles laid down in the constitution. Now, according to them, there are 3079 number of villages. If it becomes 4,500 or it becomes 3,500, will it make it unconstitutional? No violation of Article 14. According to the need, what is the main idea of changing the territory of BTAD now? That some areas there are more Bodo peoples, those were not included in BTC to govern under the 6th schedule provisions and BTC. And some areas within BTC, there are less number of tribal people and more number of non-tribal people. There are a lot of other counter demands also. So we want to solve that problem. Those who genuinely deserve to be governed by the principles of 6th schedule of the Constitution of India, they should get the benefit of it. They should not be deprived. And this is precisely the aims and object and the mandate of the third accord. And for that, there is a provisions under paragraph 14 of the 6th schedule to have a commission. That commission has to work. It has to take the opinion of all the stakeholders. After that, they will issue the recommendation. It has to be placed to the assembly, state assembly. If state assembly approves it, then it will go to the central government for a constitutional amendment. There's a huge exercise left over. It cannot be done overnight. And that exercise from 2020 could not be completed because of one is COVID reason. For 2.5 years, it was wasted. And the chairman passed away in the meantime. And now things are at a standstill, but we'll definitely start it. The litigation may be one of the reasons why the government is not going ahead. Second ground they have taken that second accord was signed after prolonged consultation. Whether that was not done in the third accord. The third accord also says the same thing after a long negotiation. And what is the time period between second accord and third accord? It is about 17 years. Their ground B, page 79, Lordship will kindly see. For that, before the second accord was signed on 10/2/2003, as many 30 rounds of discussions were held by the Government of India with the stakeholders, which finally culminated in the impugned memorandum of settlement. It is a part of the record during the tripartite talks. All important Bodo individuals, groups, organizations were consulted and kept abreast with the progress of the talk. Here also, Lordship will kindly come to page 154. The first paragraph 1. The Government of India, the Government of Assam have been making concerted efforts to fulfill the political, economic, social, cultural, and identity-related aspirations of people. Tripartite agreements of 1993 and 2003 were signed, leading to creation of Bodoland Autonomous and Bodoland Territorial Councils under the 6th schedule to the Constitution of Bodo inhabited areas of Assam. APSU and its associate organizations, as well as various factions of NDFB, continued with the demand for separate statehood. Negotiations were held with Bodo organizations for a comprehensive and final solution to their demands while keeping intact the territorial integrity of the state of Assam. Here also it is followed by a detailed process of negotiation and consultation. I do not have the figure how many rounds of consultation. Earlier, according to them, it is 30 rounds. We do not know that part, Lordship, but it is very clearly indicated and mentioned that negotiations were held with Bodo organizations. Nobody is left out for a comprehensive and final solutions to their demand while keeping intact the territorial integrity of the state of Assam. So my humble submission here would be, Lordship, that all the major representatives and the organization of BTC were consulted. Their own party was consulted, BPF. They are part of the whole exercise. How can the BTC regime under the then CEM, Honorable Hagrama Mohilari, he was the CM at that point of time, and the other persons who were number 2 and the speaker, etc., were part of the state government. Chandan Brahma was a state cabinet minister, and the other persons who were there, Lordship, they were all part of the either BTC government or the state government. So they knew whatever was going on, and finally it culminated with the signing of the agreement on 27th of January 2020. Now, if we look at page 9, number 4, page 9. So all these persons are actively an integral part of the either the BTC government or the state government. They themselves has mentioned in their petition at paragraph 4, at paragraph 7, paragraph 6 and 7, they themselves, paragraph 6, they have clearly stated, the petitioner number 2 is one of the signatory of the first accord. He has been 4 times elected member of parliament. The petitioner number 3 has 3 terms cabinet minister and one of the signatories of the second accord. Petitioner number 4 is the former deputy chief of BTC from 2003 to 2020. So petitioner number 4, Kempa Borgiari. So page 39, Lordship's third line. The petitioner number 4 is the former deputy chief of BTC from 2003 to 2020 and also one of the signatories of the second Bodo Accord. The petitioner number 5 to 9 are all public spirited persons and signatories of the second Bodo Accord. So they are all part and parcel of the whole exercise. How can they say in ground number 2 that major organizations are not consulted? These are blatant incorrect statements before this honorable court. And my friend is now saying out of those 95, no 85, 68 are hardcore member of one of the political party. 64 out of these petitioners are their active members of a political party, PPF. You have to go to the ballot. You have to go to the people if you want political supremacy. Not taking course of the Honorable High Court. That is not the route. I'll place all the judgments of my Lord Justice Chandrasur and other same issues. In political democracy, the elected representative have the say. And they are all political representative number 1, and they were all elected persons. After the signing of the accord, they may have lost their power. But when the accord was signed, they were elected representative. So according to them, they cannot play hot and cold at the same time. When I am in the power, I say yes to third accord. And when I am out of power, I find fault at the third accord. This is precisely happening here. Going further, Lordship. The next ground. Not a single ground is acceptable in my humble submission, Lordship. There are about 35 grounds. Then ground 2, ground C. Ground C, they refer to a Supreme Court judgment, and their condition is that page 83, applying the above parameters to the instant case, since the explicit objective of clause 2.1 of the MOS is to augment area of BTC, clause 3.1.2 is contrary to the stated objective, therefore does not pass the test of Article 14. They have to justify. If augmenting area of BTC, what is augmenting? Adding. How can they have objection? Suppose after the commission completes his work and commission finds that 500 more villages are to be added. What can be their objections? They do not want betterment also of the Bodoland peoples now. They are written things. This is not my submission. Their submission in the grounds. For that, augment of area indicates geographical area and territorial boundary of BTC would certainly be increased and extended beyond its eastern and southern limit as desired and demanded by Bodo, whose leaders are signatory of the accord. So they, indeed, they have stated, Lordship will kindly read it. That to augment areas indicates that the geographical area and territorial boundary of BTAD would certainly be increased. So they themselves have accepted. If our territory increases, I represent BTC also in this case. If my area increases, Lordship, it is more the merrier. More area I will get. There is always a demand for increase. There is never a demand for decrease in territorial issues. So they have objection because they are not at the helm of affairs now. This is a about turn. When they were power, they want the BTC area should be expanded. Now they want decrease. So contra argument is that they do not want expansion of BTC area. If this goes to the public domain, Lordship, what will be the fate? I do not know.
I'm sorry, Lordship, I have to just indicate the last 4 lines of that paragraph. It should be put fairly. What is our ground? We are opposing exclusion. That same ground, the last 4 lines we'll see. If submission is made, it should be made factually correct. Please read the last 4 lines of the paragraph.
Everything is before the honorable court.
Of the same paragraph, Lordship, last line.
All these were not placed. That is, I took the responsibility of placing their case now and giving the counter arguments. I went through all the videos and we have noted all these things were not placed before this honorable court. So we have to place their case also. Later on, they will say that we have all the grounds. Those grounds were never dealt with by the honorable court. We cannot take this very lightly. And I do not want to spend court's time unnecessarily. Even I have many other cases today, but it is my duty to place the actual facts. No point of placing the grounds. Actually, I never place, but here it is necessary. In this case, how they are trying to maneuver the way. I am not using the word mislead the court. At least to that extent, I am not going till now. Mislead the court. E, that the detrimental political move of the government of Assam to exclude the villages contiguous to having continuous non-tribal from the PTA by way of appointing a commission under section paragraph 14 of the 6th schedule is a dangerous action akin to opening a Pandora's box in the matter of settling the border either present BTAD or 9 other more autonomous districts as existing in the northeastern region. I do not know how they are saying this. Under the Constitution, 6th schedule, paragraph 14 is very clear, including Article 3 of the Constitution. Recent development, Lordship knows. What happened in Jammu and Kashmir? A separate state, separate union territory has been created. The central government has full power to change the territory. Although we said the federalism, India is not the federalism in its true letter and spirit. The extreme power lies with the central government. But nobody can do it arbitrarily. That is why paragraph 14 of the 6th schedule is there. What is paragraph 14? Appointment of a commission to inquire into and report on the administration of autonomous districts and autonomous regions. The governor may at any time appoint a commission to examine and report on any matter specific by him relating to the administration of the autonomous districts and autonomous region in the state, including matters specified in clause C, D, E, and F of subpara 3 of paragraph 1 of this schedule, or may appoint a commission to inquire into and report from time to time on the administration of autonomous districts and autonomous regions in the state generally and in particular with the provisions of education, etc. But here we have to concern about C, D, and E, F of paragraph 1 of subpara 3. Lordship will kindly come to paragraph 1. Autonomous districts and council 3 says the governor may by public notification include any area in of the said table, exclude any area from the said table, create a new autonomous district, increase the area of any autonomous district, diminish the area of any autonomous district, unite two or more autonomous districts or part thereof so as to form one autonomous district. These are all within the norms, within the acceptable principles, and within the acceptable procedures laid down in the Constitution. So whatever has been done, it is permitted. It is a permissible exercise. So their threat or their apprehension that it will open Pandora's box, it will create political instability, all these things, Lordship, will not receive any acceptance in a judicial scrutiny. Whether it is detrimental political move, according to them, it is a detrimental political move. Whether it is detrimental or it is beneficial, time will tell. That situation has not arisen. And there is no grievance in BTC. Except this petition, we have not heard anything. We have not seen anything in the media also, that people are unhappy with the third accord. It is in general and in open public domain. Nobody is offended. Why they will be offended with the third accord? If Lordships looks at the development activities which are indicated in that, therefore at one point of time, when this case was taken up by the court number 1 at one point, we have to ask to submit a report. What are the developmental activities in terms of the various clauses and annexures and schedules of the third accord? What we have done, whether we have fulfilled the commitments. We have placed that affidavit also. The court wanted to see whether the developmental activities are taking place in terms of the third accord or not. Right? Last 20 years, the Honorable Court wanted to see. We place everything, it is a part of the record. That I am not arguing on that. That cannot be a ground. We have to test it from the mandate of the Council, whether we have violated any constitutional provisions in this accord. So whether it's a political move, it is detrimental or beneficial at this stage, and this is not the right forum, Lordship, in my humble submission. Those can be part of the political debates, either in the television studio or in political parties, meetings, or finally at the time of election, the battle of the ballots. At that stage, those things will be weighed. Now next, another ground F, that for last 17 years long period, the outgoing BTC government of the 3 consecutive terms from 2003 to 2020 have spent crores of rupees for the development of villages, areas, township of BT, which are claimed to be inhabited by non-tribal communities. How can we know at this stage? No doubt, a lot of developmental activities has taken place during that time. But after this exercise, suppose some area goes out, but some areas will come in also. And till now, it is not visible to us whether some areas will go out or some areas will come in. That exercise is not yet completed. Under paragraph 14, the commission will finally give an opinion that some villages are to be included, some villages may be excluded. Let us take that situation. Those areas which will go out, no doubt BTC fund was, let us test their argument. BTC's fund was utilized for development of that area. Suppose few streets were constructed, few schools were developed. Some areas will come in also. Those areas also will have schools. Those areas will also have streets. Those areas will also have water supply. Those areas will also have medical establishments. So this is a balancing thing. The concern about all the parties who are part of the third accord signing is that no person, if a person who is a tribal, he should get the benefit of 6 schedule norms. That is the concept. And if a person he is non-tribal, he should be out of those benefits. It's a win-win situation. Why should he get special benefit if he is a non-tribal and he is taking benefit for the matters which are meant for benefit of the tribal people. Now, politically they are not getting the advantage. That is why this PIL has come up to restrain that beneficial action. Somebody else will get the political mileage. But as government lordship, we have nothing to do with that. Because both UPPL and BPF, we are part of that signatures. APSU at that point of time, they have changed their color to become UPPL. Just like in 2003, BPF changed in, no, BLT changed into BPF. Here also there is a transformation. Some organizations later on became political party. Just like AGP was formed at one point of time with the student leaders at that point of time. 1985, I'm going back. These are political events. So this 17 years funding, etc., we have nothing to do with that, lordship. That will not make the accord unconstitutional or illegal. Paragraph 88, page 88, middle portion after the italics. In this regard, the petitioners respectfully submitted the commission formed under notification dated 28/7/20 under paragraph 14 of the 6th schedule does not include major stakeholders like the BPF, Bodo, Sahitya Sabha, civil society, etc. So that means the notification is correct. Only problem is that some persons were not included. This is a contra argument from their side. At one time, they are saying that this cannot be done or this should not be done. Now they are saying that the commission has been constituted. So you take some of the representative from us. That will become a private right. Read petition 226 before learned single judge, not in PIL. H, page 89. For that, it is alternatively submitted that committee formed under paragraph 14 of the 6th schedule is illegal in as much as its composition is not in terms of 3.2, which reads as commission so and so, the persons who can be included. So if it violates 3.2, whether 3.2 will go or the notification will go, they can test it before in a proper writ petition, lordship. Then the constitution of the committee, etc., will try to justify if something needs to be amended. That can be always done. Then page 90, that they submitted some representation, there is no response. So that can be again a prayer for mandamus directing us to dispose of their representations. What is their representation? That can be a separate cause of action, which they can definitely take legal recourse, but not through this PIL, in my humble submission. Whoever has submitted representation, if they are represented not attended to, lordship may please to give a direction that within 13 days dispose of that representation. I don't think the BTC or the state government will have any objection, neither the central government. Next, J. The impugned MOS has been entered into for extraneous political consideration. This is what I am trying to emphasize. This is a politically motivated case. What extraneous political consideration? Whose benefit? Their own party leaders were part of the third accord. They were a political entity at that point of time. Even today, they are a political entity. If certain provisions of the accord is not benefiting to their interest, will it become illegal? That is the query before this honorable court. Whether it is arbitrary, whether it is discriminatory, or whether it is violative of Article 14, 19, 21, 25, and 29. So these extraneous political considerations, they have to elaborate before this honorable, not just saying that it is arbitrary, illegal, and violative of Article 14. Political decisions, political benefits, etc., are not governed by Article 14. Article 14 has a different meaning. There can be a lot of political decisions, construction of a Ram Mandir, construction of a masjid, etc. It will benefit some political parties, it will not benefit some political parties. But that will not make Whatever is permissible under the constitution, that has to be done. So to reap political benefit, this is not the forum. This honorable court is not the right forum, appropriate forum, or permissible forum to reap political benefit. It is very clearly visible now from their own writings that with some political motive, they have approached this honorable court. So I am just reiterating their submissions, their grounds. These are not our stand. Our stand will stand on constitutional mandate. We will counter every point constitutionally and the various judicial pronouncements of the Honorable Supreme Court regarding federalism, cooperative federalism, etc. But their own case, how they have projected their case, it is out and out a politically motivated case with all political inputs here. Next, 3.1.2 does not have reasonable classification based on intelligibility. These are standard lines, but they have to elaborate with facts. L is next line. 3.1. Roman 2 is extremely restrictive and cannot only form relevant criteria. Their explanation is required here also. But one point that it can be one of the criteria. Cannot form the only relevant criteria. There has to be other criteria. Let them explain. For that, the next page, 3.1.2 have prescribed a protective discrimination, and the challenge having laid down, it is the burden of the state to demonstrate providing objective material as to what prompted the state to enact the same. Failure to adhere to this mandate would render the same unsustainable. So first, they have to give us proper submission on these submissions on grounds. (93) The impugned clauses amounts to undermining the terms of second accord, which was arrived at after extensive deliberations with all the stakeholders. Further, it further amounts to diluting and undermining the autonomy and territorial integrity of the Autonomous Council constituted under 6th schedule of the Constitution. So, according to them, the third accord dilutes the provisions of the earlier accord, and it also dilutes and undermines the autonomy and territorial integrity of the BTC Council. So, if more area is added, how it can dilute? More beneficial projects are given, how it can dilute? One of the ground is page 93. For that the exercise of exclusion of village under offending clauses without any demand being raised by any quarter. This area, in my humble submission, accepting their thing, this area will go into by the commission during its exercise of its work entrusted to them by the governor. They have to seek opinion from all stakeholders, and they have annexed 1 or 2 documents from some villages. They do not want to go out of BTC. They have annexed those representation. Those will be considered. Those will be looked into. Thereafter, the commission will give an opinion whether those villages should be excluded or included or remain intact. And that decision of the commission is not final. It has to go through 2 different tests thereafter, which is according to the Constitution, that it has to be placed before the assembly. All these things are part of the Constitution. So, the exercise of under offending clauses without any demand being raised by any quarter. So, they have produced 2 or 3 representatives that they do not want to go out. There can be other documents which will say, give a contra picture also, that we want to go out because we have very few numbers of tribal population here. There can be. And another very interesting part is that some areas which are not part of BTAD will be brought under BTSC. The villages in Karbi Anglong, the villages near Lakhimpur, those are Boro inhabited villages. Those will come under now. For that, after the opinion of the commission, It has to be ratified by the parliament also. Then page 95. The fourth line, and its geopolitical BTAD was created and founded as an effective political mechanism to help ensure the safeguard and protection of the rights of the indigenous Bodo tribal people over their land and ancestral territories, political, social, economic, linguistic, and cultural spheres from onslaught and aggression of the other advanced outsiders, new settlers, and such other. A shift in the political equilibrium in BTC resulting from exclusion of villages and the likely expansion of the ST list in Assam has the potential to keep Bodos out of power in the BTC and push Bodo organizations for reviving their homeland demand. In the aforesaid ground realities, the petitioners respectfully submit that if the offending clauses of the MOS are implemented, it will disturb the delicate social fabric and equilibrium, which may spiral out of control and bring back violence and instability in a very strategically important region of the nation. My response to here is that they are showing apprehension, Lordship. They are expressing apprehension because of there will be a shift in the political equilibrium. Who are the other parties who are part of that accord? They are equally positioned political entities of BTC, the NDFB, the EPSU, and the third organization. Plus the BPF themselves are part of that accord. Who else is left out? Let them indicate first. Bodo Sahitya Sabha, their own admission in their petition is that their role is to promote literature and writers. Page 38. Page 38, they says, the petitioner number 1 is a Sahitya Academy recognized non-political organization that was formed on 17 March 1985 with the aims and objectives to give scope for literary works to the Bodo writers and create new writers among Bodo community. So their opinion may not be very effective here in this political exercise. Whose opinion is important? BPF's opinion is important. UPPL's opinion is important. NDFB's opinion is important. Erstwhile BLT's opinions was important. EPSU is it's a state organization. All these organizations are part of the accord. Which is left out in my submission is a Sahitya Academy, the main petitioner, Lordship, Bodo Writers Academy and others. Then this petitioner number 1, Bodo Sahitya Academy. They are not part of the accord. I fully agree, Lordship. Their role is totally different. So that political equilibrium shift, etc., it will be between BPF, UPPL. Or there may be a third political party tomorrow. We do not know. But that will not change. And that will not make the accord unconstitutional. So there are series of other grounds, basically, if Lordship comes to the competition between the second accord, third accord, etc. From all these grounds. One ground is page 100. My learned friend the other day, he submitted about Article 163, 162, etc. I'd like to read out, and what is the ground I do not understand. That's why I like to read out, because he made some submission on that. Article 162. For that, in the context of notification dated 28/9/2020, the issue that arises for consideration is the nature of the discretion that is to be exercised by the governor while exercising his power conferred under subpara 3 of para 1 and para 14 read with para 20b of the 6th schedule. Whether such discretion is absolute or subject to Article 163(1) of the Constitution. In this regard, the petitioner submits that the exercise of power by governor under para 14 of the 6th schedule is subject to Article 163(1). This intent is clear from the insertion of para 20BA of the 6th schedule with effect from 12/9/1995. Similarly, exercise of power by governor under subpara 3 of para 1 of the 6th schedule is also subject to 163(1). The intent is clear from the insertion of 20BA of the 6th schedule on 12 September 1995. The important part is that at that point of time, BTC was not formed. At that point of time, this whole provision is related to Karbi Anglong as well as Dima Hasao. It may be noted that BTC, Boro Autonomous Council was formed in 1993. The aforesaid amendment insertion was made in 95. Thus, it must be understood that the Parliament in its wisdom chose to make para 20BA applicable only to North Kachar and Karbi Anglong and exclude BTAD. Thus, with respect to exercise of power qua BTAD, the governor is constitutional governor and therefore Article 163 will squarely cover. So whether this governor will be a constitutional governor or a discretionary governor, that is not the issue here before this honorable court. Recently, in BTC, one case came up when in 2020, the governor, by exercising his power, dissolved the BTC and brought the whole regime under his control and imposed governor's rule. At that point of time, this query was raised and it was decided by this honorable court. The governor in BTC is a constitutional governor. That means he acts at the aid and advice of the state cabinet. So now, while issuing this notification of 28 September 2020 regarding constitution of the committee or the commission, whether the state has the power or not, that notification. This is one of their ground. While doing so, that notification says the governor will act as the aid and advice of the state government, and the state government has to take note that some areas of the state will be brought under BTC and some area will go out. So when that exercise is to be done, it has to be done by the state. The BTC cannot, the BTC authority, suppose the government in Kokrajhar, can they issue a notification covering the area which is beyond their territorial jurisdiction as of now? Whether the area in Karbi Anglong, whether the area in Lakhimpur can be governed, whether some areas which the BTC or the government under the Act Court wants to bring within the territorial jurisdiction of BTC. Those are, at this stage, it is beyond their territorial jurisdiction. So there is no doubt that the governor exercises his power at the aid and advice of the governor, but that does not dilute in any manner the autonomy of BTC. The overall scheme of things has remained unchanged and it has no conflict at all. Nowhere it has been said that for the purpose of BTC area, the governor will exercise his power on discretion. That is not the mandate here. 20B, lot of areas are demarcated. For whom? For Karbi Anglong and Dima Hasao. Why there is no change in 20BA after 2003 when BTC was constituted? There is a long debate on this, Lordship. In fact, we spent 40 days arguing this point before my Lord Justice Achinta Molla Bujurba and another honorable judge in the division bench on this point. When that case came up, D.K. Mishra and late Niloy Dotto was there on the other side. So there was a conscious decision not to amend 20BA after formation of BTC in 2003. It remains intact. That means 20B, whether it is applicable to BTC, no, it is not applicable. Therefore, all these things, what is the implication of that means? That the governor in respect of BTC will act as the aid and advice of the government of Assam. Government of Assam represented by the cabinet under Article 162 and 163. 20B, Lordship will kindly see the amendment 20BA. Exercise of discretionary power by the governor in discharge of the functions. Lordship will see a lot of departments are there. These paragraphs included various areas. After consulting the Council of Ministers and North Kashmir Autonomous Council or the Karbi Anglong, as the case may be, as such section. So governor will only consult, he will not act on aid and advice. That is the distinguishing factor here. So in respect of these areas, Lordship, various paragraphs and indicated, Lordship. So in all these fields, the governor will only consult the Council of Ministers, but he will not act as per advice and aid of the Council of Ministers. Here, the power of the governor is discretionary. He is not a constitutional governor here. He is a discretionary governor here. That is the distinguishing factor. He will have the final say. But in case of other activities in BTC, the governor will have to act as per the advice of the government of Assam, comprising of ministers from BTC as well as everybody. Chandan Brahma, who is one of the signatory, was a part of the cabinet. So he comes under Article 162 when those decisions were taken. 162, who comprises the Council of Ministers. 162, Lordship will kindly be pleased to come. Extent of executive power of state. Subject to the provisions of this constitution, the executive power of the state shall extend to the matters with respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited to the executive power expressly conferred by this constitution or by law made by parliament upon the union of or authorities thereof. 163. The Council of Ministers to aid and advise governor. There shall be a Council of Ministers with Chief Minister as the head, to aid and advise the governor in exercise of his function, except in so far as he is by or under this consider required to exercise his function or any item at his discretion. So in Karbi Anglong and Dima Hasao, it is discretion. For rest and those subjects which are indicated in 20BA are in those areas only the governor have the discretionary power. Rest, he will have to act within those 6 scheduled areas also in NC Hills as well as Karbi Anglong also. He will have to act as per the aid and advice of the cabinet. So we have no quarrel on those propositions. So according to them, with respect to power except BTAD, the governor is constitutional governor and therefore Article 163 will squarely apply. So we have no conflict on that. So how can it be a ground for challenge? We agree. And therefore, the notification of 28th September 2020 is valid. It has the constitutional backing. Page 108. Another clause. Rest I am skipping because these are basically vague grounds which will simply waste the Honorable Court's time. 108. For that clause 8.1, which talks about the creation of a separate department to deal with the affairs of BTC, is also detrimental towards overall interest of the people of BTAD and also of the BTC administration. Its basic malafide intention is to overpower, override, and overrule the paramount authority of BTC administration and thereby ultimately getting scrapped the entire BTAD and BTSC self-governing geopolitical and administrative entity in totality in the long run, which cannot be accepted. this department, Lordship, in my humble submission, earlier it was the Welfare of Plain Tribes and Backward Classes Department. Now it is a separate BTC department. Are they free to act on their own whims and fancies, whoever may be the department, whatever may be the nomenclature? They have to do it under a guided principle, which flows from the Constitution, which flows from the Assam Rules of Executive Business, which flows from the BTC's own governing rules, and which flows from the various acts and statutes and office memorandums issued for running the business of the departments. It is a guided thing. If anything goes wrong, they can immediately come to the court. From 2005 to 2020, this department, Plain Tribes and Department of Plain Tribes and Welfare of Backward Classes, that department was doing that. If anything is done to override the power of BTC, that could have been challenged. So it never happened. Therefore, there was no challenge, no grievance. Today, a new department has been created so that the activities of BTC has increased much more. Whatever was there in 2003, it has manifold increased during the course of last 15 years, and now things are progressing at a much faster pace. So when a department was handling generally of various activities of plain tribes and backward classes people, if they have to give importance to one 6 schedule area, that creates an administrative block sometimes. To overcome the red tapeism, faster progress in developmental works, a separate department is in. Yesterday, government has decided to close 3 departments, Department of Employment, etc., which has no business now. So these are administrative calls of the department, government. When that department is no longer needed, now everything is done online. So employment exchange and all these things have become redundant today. So 3 departments were closed 2 days ago in Assam, because that is the need of the government. When it is felt that this particular earlier department, that Welfare of Plain Tribes and other backward classes department, it was overburdened with work. It is not that only 3 6 schedule areas. We have about 10 to 15 autonomous council, missing autonomous, Rabha Hasong autonomous, then Deuri, Kosari, Sonowal, etc. All these councils has to be looked after by a single department. So therefore, it has been segregated and given a separate. It will ease the work. What they are saying that you can nullify the intention, it will overpower the BTC administration. In my humble submission, this is not at all acceptable submission on their part. These are purely administrative areas. So exclusivity is given there. If Lordship is pleased to look at the list of developmental activities which are projected in the MOU, it starts from page 161. List of additional subjects, Annexure 1. Implementation of schemes under rural electrification, non-conventional energy, solar, renewable, mini-hydel projects. Welfare development of the minority communities, indigenous faiths. Trade and commerce with BTC subject to provision of so-and-so. Medium industry to be added with small cottage rural industry. So a major chunk of industrial development. Education to be added to animal husbandry, etc. Technical nature to be added to flood control for protection of villages, paddy field. Vocational education to be added to education, that is to say primary education, higher education, including vocational training. Protection of wildlife. So these are additional subjects. Then next, Lordship will see education and other important institutions, 10 numbers. And these are not small infrastructure and areas. Upendranath Brahma Central University at Boroma, National Sports University, Sports Authority of India Centers at Udalguri, Baska, Sirang, Institute of Livelihood Management at Tongla, Northeastern Regional Institute of Medical Science at Roumari, Hotel and Tourism Management, Regional Campus at Indira Gandhi National Tribal University at Bhairavkunda, Bodoland Movement Memorial Museum at Salibari, National Institute of Technology at Udalguri, additional Navodaya Vidyalaya. If we look at the age of the 3 6 schedule areas in Assam, both Karbi Anglong and Dima Hasa were born sometime in 1955. So they have a long, so the progress and development in those areas has taken place from 1955. This is a newly developed area, BTC area, from 2003. That is why only BTC separate department has been created. Those are already the main major developmental work for those areas have already done. It is not that BTC area was not developed before 2003. Those areas are still developed. But with these additional areas, now education government of Assam, then government of Assam's additional parties lordship from another 11. Education is page 162. Then for industries and employment generation, government of India has 7 scope, including railway coach factory. Number 7. Various industrial development activities, lordship. Government of India and from government of Assam also another 9. Then page 164, government of India, 7 big projects of national highway status, stadiums, flyovers, overbridges, cancer hospitals, etc. From government of Assam, 3 areas. So when these kind of activities are contemplated and projected in the MOU, if the government feels that the general department is not self-sufficient or it will not cater the needs without there being delay, wants to have a separate department exclusively earmarked for the activities in BTC, fund flow and etc. Various activities. That department has a role under the scheme. So it cannot be said that it is trying to dominate the activities of BTC. BTC's regime will run their show as per the norms given under the various provisions of law. The government will run as it is. These are administrative work, the fund flow, submission of utility certificate, utilization certificate, etc. I'm just giving a small part example. The fund has to be channelized, it has to be timely given. Therefore, there is no delay in execution of the projects. This is a welcome step. We cannot see it as with some suspicion. Then, lastly, Lordship. So these are the grounds. Now, what is our counter? Lordship will be pleased to take our affidavit now.
Counter
Counter of the state of Assam. Our private bookings.
open political.
Yes. Excellent.
R1.
It is R5. R5.
R5.
Mendel. Yes. I would like to place few paragraphs, Lordship. First is paragraph 4. We have more than 50 paragraphs, but I will read only about 10 to 11 paragraphs.
R4.
Are from paragraph 4. First, I will read 4, 6, 9, 10, 12, 15, and 17. Then I will go to other paragraphs. May I read it, Lordship? As regard the statements so-and-so, the environment so-and-so, the various clauses highlighted in the are not discriminated, arbitrary, illegal, as agreement was arrived at after extensive consultation with the stakeholders. The Memorandum of Settlement, Third Borough Accord, was signed on 27/1/2020 between Government of India, Government of Assam, and the representatives of all Borough Students Unions, APSU, National Democratic Front Boroughland, and United Borough People's Organization, with the then Chief Minister of Assam, Sarbananda Sonowal, then Honorable Cabinet Minister of Assam, Dr. Himanta Biswa Sarma, and the CM of PTC, Sri Agrama Mohilari, as witnesses. The allegations of lack of proper negotiation in the PIL is not correct, as unlike the Second Borough Accord, which was signed only with the representative of Boroughland Liberation Tigers, BLT, on behalf of Bodos, the Third Borough Accord was signed after several negotiations with Borough organizations, as highlighted in the clauses of Memorandum of Settlement, and including NDFB, APSU, UPPO as signatories from Bodo side. As such, the aforementioned clauses and notifications are not violative of the fundamental rights granted under so-and-so. The petitioners of the PIL also failed to appreciate that Government of India and Government of Assam had making consistent efforts to fulfill genuine aspirations of the people, restore peace, and accelerated development of the area. Discussion for the Third Borough Accord were held over several years, involving a number of leaders, representative of organizations of indigenous communities, and other stakeholders. Several number of tripartite talks were organized since 2013 itself, when agitation for Bodoland state had peaked. The Third Borough Accord was held across the state due to convergence of all Borough groups on the issue. The media reports at the time of MOS are indicative of the wide public support, as the general masses hope for accelerated development of the region through implementation of the MOS. The notification of WPT Department dated 29/9/2020, partially modified by notification dated 24/12/2021, appointing Dr. Ashish Bhutani IS, Principal Secretary, Government of Assam, as the chairman in view of the demise of incumbent chairman Sri P.P. Verma. The notification is not violative of the fundamental rights of the commission, was constituted for furnishing recommendation for alteration of the area included under Bodoland Territorial Region, and is not violative of the fundamental rights of the Constitution, as the recommendation will be the advisory in nature, and the same will be considered for implementation by the government after observing due formalities and process. Clause 3 of the 6th schedule empowers the state government to undertake constitution of such commission. I have placed law. Clause 3.1 read as exclusion of villages currently under BTAD which are contiguous to non-6th schedule areas and have majority of non-tribal population. This clause is similar to clause 3.2 of the Second Bodo Accord, which talks about inclusion of additional villages of more than 50% Bodo people and aims at balancing strike of various communities. This clause mentioned about exclusion of minority village which are contiguous to non-6th schedule areas. Thus, 6.1 Roman 2 is a natural corollary to clause 3.1.1. Further, the petitioners have tried to misguide the Honorable High Court by stating that there was no demand from any quarter for exclusion of the villages. In fact, some non-Bodo organizations, non-Bodo Suraksha Samiti, have agitated in the past for exclusion of their villages from BTAD, alleging that they were facing discrimination. Clause 3.1 speaks about increasing of seats after alteration of area. Justification of alteration of area is mentioned in earlier paragraph for clause 3.1.2. Moreover, this clause is similar to clause 4.2 of the second Bodo Accord, which highlights about the seats in the proposed council. Clause 3.2 says the commission will include representative of the state government as well as other stakeholders, including APSU and BTC as its member. It will submit its recommendation within 6 months from the date of notification. This clause includes various stakeholders, including APSU and BTC. Hence, the petitioner should not have any objection to this clause. Clause 3.3, the existing Bodoland territorial area shall be renamed as Bodoland territorial region comprising of areas covered by BTAD. Although the petitioner questions the change of nomenclature of BTAD to BTR, naming of district is an administrative consideration. Further, by clause 1.3.f of the 6th schedule, the governor by public notification may alter name of any autonomous district. Hence, the objection of the petitioner regarding this clause is unjustified. So, in the accord, it was inserted that the name will be changed. All the stakeholders have agreed. Now, whether Lordship will see that clause 1.3.f. 1.3, 1 autonomous districts and council. 3, the governor may by public notification. F, alter the name of any autonomous council. And this was changed in 2nd April 1970. This F was inserted when Meghalaya and all the new districts, states were formed at that point of time. If not say reorganization of northeastern states. During that time, this power was given under the 6th schedule to the governor. That alter the name of any, otherwise Lusai district was Mizoram now. All these changes have taken place because of the need of the hour. And this has a constitutional backing. Clause 3.4 reads as Government of Assam may consider reorganizing the district subsequent to alteration of area on administrative consideration. Again, there is no illegality in clause 3.4 as para 1.3.g of the 6th schedule to the constitution provides for alteration of boundary of an autonomous district by the governor through public notification. Similarly, clause 1.3d and 1.3e talks about change of district. Hence, the objection of the petitioner is unreasonable. So that power is also there. Clause 1.3, all this D and E. Another clause they have challenged is 4.4. Executive function of BTC shall be exercised to the chief executive officer, not below the rank of Principal Secretary of Government of Assam. Senior most officer of various departments of BTC shall not be below the rank of Additional Secretary to the Government of Assam. This clause highlights the rank of Principal Secretary and other officers of BTC. BTC at present consists of 5 districts and generally officers of the rank of commissioner and secretary, joint secretary are made the deputy commissioners of the district. Since BTC is an administrative setup at the Apex Council, it is natural that a suitable high-ranking officer is posted in the rank of chief executive officer of BTC. Hence, the objection of the petitioner is not justified. So when a higher ranked person is given that position, it is always beneficial than the subordinate officers. 7.2, the government of Assam will take effective measures to protect khas lands, grazing lands, and water bodies from illegal encroachment. This clause aims to protect khas land, that means government land, grazing land, and water bodies from illegal encroachment. It is the responsibility of the administrative setup at all levels to protect such areas from illegal encroachers. Since this is a general clause, the petitioner should not have objection to this clause. The petitioners of the PIL do not establish the exact, I do not know what is tautology between the various clauses of the 3rd Borough Accord and their changes and their charges of violation of fundamental rights under 14, 15, 19, 21, 25, 29. Their charges are completely baseless. So I am already submitting, Lordship. They have to project how these provisions of the constitutions are violated by this accord. Till now, Lordship, we are not very clear on that. 8.1 reads, the government of Assam will create a separate department to deal with matters relating to councils under 6th schedule of the Constitution. This clause aims to focus attention on development of Bodoland and affairs of BTC and is aimed at performing the roles which was earlier performed by the WPT and BC department in the BTAD matters apart from other matters. I have already made an elaborate submission on this. One exclusive department has been created, Lordship. That department was never running BTC, neither it has any intention of running BTC. It will just supplement. The funds should have free flow. There should be no administrative blocks in various developmental activities. Earlier, one general department was looking into it, apart from other activities. Now, an exclusive department has been earmarked for that. Then Lordship will kindly come to 6. The third tripartite agreement has been made considering all-round development of the Bodoland territorial region and to protect the constitutional right of the people of the region. Then paragraph 9. The deponent denies the averment made by the petitioner and humbly begs to submit that the recommendation of the committee is yet to be received and subsequent implementation of the same, if required, will be done only after following due legal procedure, including thorough constitutional amendment if required. If there is any change of geography or the territory, it is at the fluid stage. It is in fact not even finally taken any shape also. So when BTC was originally constituted in 2003, the accord was signed on 10th of February. Constitutional amendment took place sometime on 8th of September. Thereafter, the government of Assam has issued appropriate notification about the activities in BTC. Till that time, till the constitution was amended, Lordship. The constitutional amendment took place on 8th of September, although the agreement was signed on in the month of February, 7-8 months earlier. There also the area was demarcated. All these changes have taken place once the constitution has been amended. Without the constitutional amendment, Lordship, it cannot be done. Here also, that is why my submission from day one is, Lordship, it is a premature case on the main front. The main front is area. 5 minutes, Lordship. May I continue? So, paragraph 10, the deponent submission and notification dated 9/1/2021 was issued pursuant to clause 4 of the MOS dated 27/1/2020 with the approval of the competent authority. That, Lordship, will find it page 43.
Of your counter?
Yes, Lordship. In pursuance of the GAD department's letter dated 3/8/2020 relating to implementation of the MOU settlement dated 27/1/2020 by the Government of India, Government of Assam, and Boro groups, and in the interest of public service, the services of deputy commissioners in BTAD are partially placed with Bodoland Territorial Council in respect of so regard to the responsibility assigned to identify BTC authority. So the deputy commissioners were entrusted here. The principal secretary of BTC will accordingly forward a report annually to the personal department regarding performance of the deputy commissioner in BTAD for such developmental activities. So they are agreed by this also, Lordship. The principal secretary will, because the officers are under state cadre, these are senior officers. So their performance will have to be given to the personnel department because these officers are not permanently stationed there. And who will do it? The principal secretary of BTC, during whose area he will be performing. So what illegality is there? I don't understand, Lordship. They have challenged this, that's why I placed it. Till now, Lordship, the IS cadre is relating in Assam is Assam and Meghalaya cadre. We don't have 6 schedule areas specific cadre. Then paragraph 12. As regard to the statement made in Swetha, the deponent begs to state that the government of India and government of Assam has signed a MOU with the Boro groups on 27th, which 8.1 clause says, Government of Assam will create a separate department to deal with the matters relating to council under 6th schedule of the Constitution, including BTC. In this regard, the welfare of plain tribes and BTC, later dated 24/7/2020, had requested the Administrative Reforms and Training Department to take necessary action on the above. Also, the Home and Political Department had sought for an action taken report on the same by later dated 31/8/2020. In view of above, the Administrative Reforms, Training and Pension and Public Grievances Department, the Dan Administrative Reforms and Training Department had moved the Cabinet during the month of February 2021. Subsequently, the Cabinet approved the proposal for creation of the Welfare of Bodoland Department on their meeting dated 22/2021, and accordingly, as per decision of the Cabinet, the Administrative Reforms, Training and Pension and Public Grievance Department had issued the notification dated 10/6/2021 for creation of the Welfare of Bodoland Department. Annexure 4, Lordship will kind of Annexure 6, that Lordship will find at page 45. With reference to the above, that is a memorandum of settlement, a copy of the MOU settlement dated 27/1/2020 by Government of India, Government of Assam and BTC. I am direct to say that a separate department has to be created to deal with BTC of the 6th schedule area, including BTC. So that was the decision and it was convened. And subsequently, the department was constituted. Annexure 7 at page 47. And finally, the Cabinet decision, Lordship will find at page 49. Additional item number 5, pertaining to the administrative reforms and training and development regarding naming of Hill Area Department shall be 6th schedule department was reviewed. Instead, a new department with the nomenclature Welfare of Bodoland Department shall be created. The existing Hill Area Department shall continue. So a separate department has been carved out. So it is a dedicated department now, instead of the Hill Area HAD department, as well as the development welfare of plain tribes and other backward classes department. So this is a administrative reform, and which will simplify the action for implementation of various developmental projects and schemes in BTC area. Exclusive dedicated department, Welfare of Bodoland Department. Paragraph 15. The deponent begs to humbly submit that clause 3.1 and 3.2.2 does not violate the basic rights of the indigenous community, and the implementation of the said clause will be made, if required, only after following the due process of law. In fact, the law and order situation has vastly improved after signing of the third Boro Accord. These two clauses are relating to the areas, territory of BTC. So everything will be done as per the report, discussion, approval by the assembly, then constitutional amendment. So nothing has gone to that stage till now. But one statement very categorically we have made that the law and order situation has vastly improved after signing of third Bodo Accord. So the general people are more than happy. Things are moving in the right direction. We can very confidently say that normalcy is there in BTC area, just like the other parts of the state now. Paragraph 17, the deponent begs to submit that the third Bodo Accord is not violative of Articles 27 of the Constitution with regard to law, tradition, customs, and land tenure systems of the indigenous people, as preservation of the same is enshrined in various clauses like clause 6.2, 6.5, 7.1, 7.2 of the tripartite memorandum of settlement. The petitioners also fail to appreciate the provisions of the third Bodo Accord in entirety. Perusal of clause 5, 6, and 7 of the MOS reveals that it contains adequate provisions to secure the rights of the indigenous Boro tribal communities to address their issues relating to language, culture, identity, land rights, etc. In this regard, appropriate legal submission will be made. Now, Lordship will kindly see clause 6.2. If Lordship is pleased to take the PIL, let us test it, Lordship. 6.2. 6.2. 157 page number of the PIL. 157. According to them, it is violative of Article 27, that is language, etc., culture, tradition. Section 27 says, actually it should have been 25 and 29. But maybe it's a typographical. It should be 25 and 29. So 25, freedom of 25 is religion. Constitution 25 says freedom of conscience and free profession, practice, and propagation of religion. 26, freedom to manage religious affairs. 27, freedom as to payment of taxes for promotion of any particular religion. 28, freedom to attendance in religious instructions or religious worship in certain educational institution. 29, protection of interest of minorities, and 30 is right of minorities to establish and administer educational institution. In that area, Lordship, basically we have to think about the language, culture, tradition. Now 6.2 says, the government of Assam will notify Bodo language in Devanagari script as an associate official language in the state. I think it has already been done. Now, Bodo is the third official language in our state. That has already been implemented. Then 6.5, for protection of culture and tradition, customs. A cultural complex cum center of excellence in the name of Bodofa Upendranath Brahma will be established at Thulungapukuri, Kokrajhar district. The center will study and recommend measures for protection and promotion of language, culture, identity, etc. of Bodos residing in Assam as well as other states of India. The center will be managed by BTC with financial assistance from central and state government. What more is required, Lordship? Whole administration, whole running, whole activities will be run by BTC for protection and promotion of the language, culture, identity of Bodos residing not only in the state of Assam, but in other parts of the country. And the finance will be provided by the central government and by the state government. State government will do it through the Bodoland department. And it will be run and managed by BTC. BTC, who forms the BTC? The elected representative of BTC. Not all and sundry. the elected representative. And they will engage all the persons who are domain experts here, because the political persons may not be expert in art, culture, etc. So the domain experts will have to be included there. So there's a different system for that. There, this Sahitya Academy can be a part. There are other cultural organizations be a part. Just like in any other part of the country, in Assam also. We have a cultural department. The persons who are manning that cultural departments will be administrators. But for the technical part, there are various committees, various involvement of various persons who are considered to be experts in their field. So those domain experts will be included. And here also, 6.2 very clearly says that at such kind of a huge establishment will be constructed, it will be open and it will be done with the financial assistance of the central government and state government, and it will be exclusively managed by BTC, not by state government or by central government. That is why everybody loved the agreement, the tripartite agreement. Then 7.1. They are also agreed that when it has been inserted in the clause that the government of Assam will take all necessary steps to protect the khas land, grazing land, and water bodies from illegal encroachment. They are offended with that also. Now, what the agreement says, the tripartite agreement, page 158, clause number 7, issues related to land rights. The government of Assam may consider enacting a special legislation to provide adequate safeguards to land rights of scheduled tribes living outside tribal belts and tribal blocks and in areas outside BTAD. So the state of Assam will have a legislation for protection of the tribal people who are not living in other non-tribal belts and blocks of the state, for protection of the tribal people there. They are not part of BTC. It is not only Boro people, there are other tribes in the state of Assam. We have Kikus, we have Lothas, we have everybody in Assam. It's a very multi-ethnicity state. It's a mini India. If Lordship goes to Dima, Hasaw and Karbi Anglong, Lordship will find a lot of Manipuri people, Mizo people, Nagaland, people from Nagaland, people from Andhra Pradesh, people from Jharkhand, people from Kerala, people from Uttar Pradesh, people from Bihar. So, and we have people from Arunachal also. We have people from Garo land, Garo, not Garo land. Garo land has not been settled. From Garo Hills. We have people from Jayantia. If Lordship goes to Gwalpara district, there are a huge chunk of Garo population there. So, the state is thinking of having a legislation for protection of those tribal people who are not covered by any tribal autonomous council or the Boroland or the other 6 scheduled areas. So nobody can have any grievance on that 7.1, but they are offended with 7.2. Government of Assam will take effective steps to protect khas land, grazing land, water bodies from illegal encroachment. If I am not an illegal encroacher, I cannot have any grievance on this, whether it is in BTC or it is in Assam or it is in any other part. Khas land is the government land. Grazing land, it is meant for a different purpose, and water bodies from illegal encroachment. I'm sure they are not taking the brief of the illegal encroachers here. When we are making a prayer before an Honorable High Court, Lordship, we must see what is the prayer. If we look, if they are offended with this provision, then what does this indicate? That they are supporting illegal encroachment? Illegal encroachment from what? From the khas land, that is government land, grazing land, and water bodies. So there cannot be any illegality by any stretch of imagination that this is violative of any constitutional provision or it is in conflict with the 2003 Second Boro Accord. Their main grievance is either it is unconstitutional, that means it is having a conflict with the Constitution of India, or it is in conflict of the Second Boro Accord. I am sure, Lordship, it is not in conflict with either the 2003 Bodo Accord, that is the second tripartite agreement, or with any of the provisions of the Constitution or any other statutory laws or any other judicial pronouncement of this Honorable Court regarding encroachment of government land, water bodies, as well as the PGI and PGRs. So this point also, Lordship, it is covered. The petitioner also fails to, I'm going to paragraph 7, page 256. The petitioner also fails to appreciate the provisions of third Bodo Accord in its entirety. Perusal of clause 5, 6, 7 of the MOS reveals that it contains adequate provisions to secure the rights of the indigenous Bodo people of the MOS reveals contains adequate provisions to secure the rights of. Now, clause 5 also I have to place, page 157. I am reading the act, this agreement in its entirety. What is the overall objective of this accord? Whether this accord has any whisper of taking away the power of the BTC, or it is the welfare of the tribal people of BTC as well as outside BTC. Clause 5. Provision for Bodos outside BTAD, that means the people who are not residing in BTAD area as of now. 5.1. The government of Assam shall set up a Bodo Kasari Welfare Council for focus development of Bodo villages outside BTAD in the lines of other existing councils for place, tribes. State government shall consult Bodo organizations and existing councils before notifying areas to be included in the proposed Bodo Kasari Council. An advisory committee comprising of representatives of Government of Assam, BTC, and Bodo Kasari Welfare Council shall be set up to identify specific developmental needs of Bodo villages outside BTAD and advise the state government. The state government of Assam shall take effective measures to confer rights upon the scheduled tribes and other traditional forest dwellers, Recognition of Forest Rights Act 19/2006, on tribals living in the forest areas outside BTAD in accordance with the prescribed procedure under the Act. So all these are for benefit of the tribal people, including Bodo people living outside the BTAD area. So the mandate of the tripartite agreement is very clear, Lordship. It is taking care of the people residing in BTC area. It is taking care of the people, Bodo people or tribal people living outside BTC area. That is why it has a wide acceptance. Nobody can object to this unless you have a political conflict. Now going to paragraph 20. A quick cursory reading of the important lines, Lordship. Paragraph 20. The deponent denies the averment made by the petition and humbly begs to submit that, unlike second Bodo Accord, which was only signed by the representatives of BLT, the third Bodo Accord was signed after extensive negotiation between the government of Assam, government of India, and the members of Bodo community, including NDFB up to UPBA. So various stakeholders of the area were taken into confidence, and after a series of negotiations started from 2013, it culminated in 2020. Paragraph 21. The deponent denies the averment made by the petitioner and humbly begs to submit that the mandate and original notification dated 28/9/2020 and the subsequent notification of 29/9/2020 constituted, that is the commission appointment, for implementing the provisions of various clauses, clause 2.1, 3.1, Roman 2 of the third Bodo Accord, is to give recommendations which are advisory in nature, which will be considered for implementation only after observing due constitutional process and mandate. We are repeating it, Lordship. So the commission's role will be basically advisory in nature. They will recommend something which may be accepted, which may not be accepted. There will be a lot of deliberation. And finally, it has to go through the test in Parliament. Paragraph 22. The deponent denies the averment made by the petitioner and humbly begs to state that the clauses of third Borough Accord will not only will in no way hamper the overall economic development of BTA, rather it will bring more prosperity and peace to the region. Then 23, the deponent denies the averment made by the petitioner and humbly begs to submit that as per record, the commission notified dated 29/9/2020 as per clause 3.1 of the MOS, which besides government officials also includes following stakeholders: Sri Joyanto Bosumatari, Vice President, All Borough Students Union, and Sri Dalim Bayan, Convener, Red Cross, Udalguri. Further, the commission is supposed to interact with all the stakeholders while inviting petitions and receiving claims and objections. Hence, the contention of the petitioner that the commission is not representative is not correct. So we have done it as per the provisions of 3.1. The other day I have explained, Lordship, who are included in this committee. I do not want to repeat what's more. And 24. The deponent denies the averment made by the petitioner, humbly begs to state that the fact that the commission has received representations from various quarters stakeholders explains that the commission is involved in discussion with various stakeholders for scope of work. Since the commission is yet to complete its studies and give recommendation, hence the contention that the commission has not taken any action on the representation is not correct. If they have 2-3 representations, definitely the commission will take care of that, which they have annexed in their PIL. 26. The deponent begs to deny the averment made by the in paragraph so and so and humbly begs to state that the rationale behind clause 3.1 Roman 2 is already stated in paragraph 4 of this affidavit, and further it may be highlighted that the sixth schedule has provisions as to the administration of tribal areas only, and hence non-tribal areas are proposed to be excluded. The intention of having 3.1 Roman 2 that those areas who does not have the required number of tribal people, those areas has to be excluded from the sixth schedule area. That is one area of the commission. So the commission will finally come and examine that which area has not been included in spite of having substantial tribal population as per the norms, and which area has non-tribal population more than the tribal people and not fulfilling the requirement of having inserted that area in sixth schedule in terms of the criteria. So all these areas are in examination. And that is permissible because sixth schedule area is meant for administration of tribal areas only. And tribal areas, there is a percentage, I think 50%. So where suppose there are 20% tribal people and that area is inserted in a BTC area, that area is actually not in terms of the definition of tribal areas under sixth schedule. So these areas will be excluded. But that situation has not arisen till now. There are a lot of represent, etc. But those has to be tested. It is a fact-finding exercise. That fact-finding exercise has not culminated till now. Once that comes and once they come to a conclusion, the commission, that yes, there are requirement of changing of territory. So they will give recommendation and that will be again debated. (31) The deponent denies the averment made by the petitioner as peace and stability has emerged after signing of the third Borough Accord. In fact, the law and order situation has improved to a great extent and the incident of violence has reduced drastically. The third Borough Accord has been highly effective in tackling insurgency in the Bodo areas. Prior to the signing of the accord on 27/1/2020, various extremist organizations had been carrying out secessionist activities in the Bodo inhabited areas as well as in the other parts of the state and waging war against the government of India. Next, Lordship. The NDFB, originally known as Bodo Security Force, was formed on 3rd of the historical background we are giving, Lordship. What actually led to the third tripartite agreement? The National NDFB, originally known as Bodo Security Force, was formed on 3rd October 1986 with the aim and objective of liberating the Bodo inhabited areas of Assam from India and to form an independent and sovereign Bodoland through armed struggle. The NDFB, in pursuance of its secessionist objective, has been indulged in large-scale terrorist and subversive acts in the Bodo inhabited areas within the district of Udalguri, Kamrup, Baska, Borpeta, Kokrajhar, Sirang, Sonitpur, Dorong, Gwalpara, Golaghat, Guwahati City, Charaidao, Lakhimpur, and Karbi Anglong, causing widespread panic and feeling of insecurity among non-Bodo population and also among the Bodos who oppose the secessionist ideology of the NDFB. In view of the increasing terrorist violence indulged by the NDFB, the government of India had notified the outfit as unlawful association under the UAPA Act 1967. Till the signing of the BTR Accord on 27 January 2020, the NDA had been carrying out secessionist activities and waging war against the government of India by stepping up its act of terrorist violence, including attack on the security forces, civilians, kidnapping, extortion, and destruction of public property. During the period of last 20 years, till the signing of the MOS, NDFB was involved in as many as 1,580 incidents, which resulted in 798 deaths of 798 civilians and 62 security force personnel, and kidnapping of 287 persons in the state of Assam. During this period, the Army, Security Force, Police arrested 4,073 NDFB cadres, along with the linkmen, and neutralized 764 of them, along with several hardcore militants. During this period, the police security forces recovered 1,733 assorted arms, 29,762 ammunition, and 1,226 grenades from their possession. In view of the relentless CI operations carried out against NDFB under the unified command structure, one faction of the outfit came into ceasefire mode on 1st June 2005. So one faction of NDFB, Lordship. While Ranjan Doimari-led faction joined suspension of the operations mode on 29 November 2013, the second faction. Meanwhile, a third faction of the outfit NDFB surfaced who opposed this peace process. However, as a relentless initiative of the Government of India and Government of Assam, on 27th of January 2020, all the factions of NDFB signed a MOS with the representative of UBPO, United Bodo People's Organization, and EPSU, All Bodo Students Union, thus ushering a new era of peace in Bodoland and ending the 3 decades old Bodo movement. Now we can very safely say that there is no such organization in existence. When the second accord was signed in 2003, BLT came overground and formed the Bodoland People's PPF. At that point of time, also NDFB was in, it was functioning. From 2005, that is why one faction, if Lordship looks at the previous paragraph, the first faction of NDFB, they came into ceasefire mode on 1st June 2005. That means immediately after the second accord. The second group surrendered, or they also suspended their operation on 27 November 2013. And the third group finally came, and that was closed on 27th of January 2020 when this accord was signed. If Lordship is pleased to look at the signatories of this here, in page 160, Lordship will find Ranjan Doimari's group. Ranjan Doimari signed it, page 160. On top left-hand side, Ranjan Doimari, one group, then Govinda Bosumatari, then B. Saurangwa, and 4 Dhirendra Boru. Although 3 groups are there, I think two persons are from one faction here. All the groups have now surrendered, and They have come overground and they have assembled with the mainstream of the state as well as of the country. And I think they are holding political powers also. I think Govinda was something. They are all in the political head. In fact, he is a deputy CEM there. And the previous phase, Pramod Boro from EPSU, he is a CEM there. They were not extremist organizations, they were students' organization. So this is the background. Paragraph page 263(8). In pursuance of the certain clauses of the MOS, the outfit laid down arms on 38 January 2020. It was signed on 27 after 3 days. The outfit laid down arms on 38 January 2020 in Guwahati before the government authorities. Subsequently, all factions of NDFB disbanded themselves and evacuated their designated camps. Post BTR record, with the active cooperation of these groups, the Assam police has recovered a cache of 219 sophisticated unclaimed weapons from the BTR area till date. At present, after the signing of the Bodo Accord, violence, sabotage, and law and order issues have tremendously come down. Further, no ethnic conflict, killing of as security forces, kidnapping, sabotage, destruction of government property has taken place at the behest of NDFB. So there is no such activities now. The former cadres of NDFB are presently engaged in economic developmental activities like small farming, fishery, piggery, poultry, and other businesses in certain areas of BTR by means of entrepreneurial development and self-employment. Till date, 4,203 former NDFB cadres have been provided financial grant of 4 lakhs rupees each for rehabilitation under government schemes. These included NDFB P 1032, NDFB RD, that is Ranjan Devmari 446, NDFB S 2725. Out of these 4,203, total 2,134 former NDFB, including 1032 NDFB P 446 NDFB RD and 656 NDFBS are receiving a monthly stipend of 6,000 under the Surrender Cum Rehabilitation Scheme of the Government of India. And 2,069 former NDFB cadres are receiving stipend of 4,000 under the Special Rehabilitation Package of the Government of Assam. So all these are being done. Central government, state government are providing full package for their rehabilitation. Earlier, 177 number of NDFB cadres and 95 number of NDFB RD cadres were imparted training on different skill development courses like piggery, poultry, farming, fishery, etc. as a measure of their rehabilitation under the Swabhalamban scheme of the government of Assam. This scheme, they receive 1 lakh per cadre as financial aid. A series of orientation, training or skill development of those cadres were also organized by the SB headquarters of Assam Police in collaboration of the State Institute of Panchayat and Rural Development Department, Government of Assam. So when Assam government is also providing skill development programs and financial support, this department, exclusive department, has a role to play, which has nothing to do with the BTC activities. The state requested them to come over ground, not BTC initiated that process. The BTC, I mean, those who were running the government in BTC area from 2005 to 2020, to bring the NDFB to the mainstream lordship. It was the role played by the state of Assam, the government of Assam, as well as the government of India. In those areas, definitely the state has a role. That is not usurping the power of BTC. Law and order still lies with the state of Assam. These are all law and order issues. And for implementing that lordship, we have an exclusive department. That means the government of Assam is giving full importance to set up a exclusive dedicated department to run the activities for BTC affairs. 12, page, internal page 26, regular page 265. After the surrender of NDFB, a major militant outfit dominant in the BTAG, as well as the sustained effort and proactive counter-insurgency measures of Assam Police, the overall security scenario of the state of Assam, particularly in BTAD, has significantly improved during the last 2 years. This affidavit was filed in the month of July 2022. So for last 2 years, that means from 2022 to 2020. Now it is 4 years. We have not heard anything negative, Lordship. Lot of funds are coming. Lot of developmental activities are taking place. Lot of investments are coming up. Not only in the non-BTC area, in the BTC area, from various big players of the country. And that is possible only because there is normalcy. Assam has already lagged behind by 20-30 years because of the insurgency from 1980 onwards. Now that scenario has gradually been changing. As a result of the relentless initiatives of the Government of India and Government of Assam, the NDFB was consulted and made a signatory along with the representatives of the UPBO and APSU. And after the accord, the violent activities of the concerned organization has come to an end, with no instance of ethnic conflict, kidnapping, sabotage, destruction of government property reported, thus resulting in a new era of peace in the Boro areas. Also, owing to the above, the Government of India has recently repealed the Armed Forces Special Power Act 1958 from 23 districts, including BTAD of Assam. What more is required, Lordship? Still, we have 3 or 4 districts in Upper Assam. This upside is still prevailing. Dibrugarh, Tinsukia, and 2-3 others, but not in BTAD. That shows the efforts of the state government, the efforts of the central government is now reaping fruits. The positive results have come out. And these are not very old issues. This removal of the APSA from 23 districts, including BTAD, had happened during the course of last 3 years, not earlier. Therefore, it is submitted that any interference with the third accord may disturb the peaceful equilibrium which was achieved after a lot of efforts and the fear of the petitioners that the implementation of the MOS may bring back violence in the area are unfounded and far from reality. On oath, we are stating this, Lordship. The apprehension is totally imaginary, and maybe it is more political than actual ground realities. In fact, 3 Boro settlements have led to progressive decrease in ethnic and insurgency-related violence, because of which the Disturbed Area Notification and Armed Forces Special Power Act, APSA, have been removed from a large part of the state, including BTR. The prevailing peace is conducive for development and the best interest of the public. The violence profile of the BTR area has been given at Annex 10. Lordship may kindly come to page 293. It starts whatever I have read. The major portions are mentioned from here. Annex 10, new era of peace in BTR. The first part I have said. Then some important incidents committed by NDAP are as follows. Lordship will kindly see. Serial bomb blast that took part in 30th October in Guwahati, 4 towns of Assam, including Guwahati. Killing of additional SP Guljar Hussain. All these details are here. I do not want to repeat. Then 5 killing of specific group Hindi-speaking people. Then 6 killing of specific group Muslims. Then 7 killing of specific group Adivasis. Killing of attack on civilians, etc. Then page, Lordship will kindly come. Page 56, paragraph 15. The surrender of NDAP, a major militant outfit dominant in BTAD, as well as the sustained efforts and proactive counter-insurgency measures of Assam Police, the overall security scenario of the area of Assam, particularly in BTAD, has significantly improved during the last 2 years. This was signed on 22nd June 2022. As a result, casualty in case of both civilians and security forces has significantly came down in the recent years. A year-wise violence profile in the BTAD after the signing of MOS since 28/1/2020 till date and last 10 years in Assam is shown as Annexure 1. Owing to above, the government of India has recently repealed the APSA from 23 districts, including PTAD of Assam. The Lordship will kindly see next page. Violent profile of NDFB in BTR after signing of the MOS. In Baska, no incident, extremist kill 0, arrest 1, civilian kill 0, security force kill 0, person kidnapped 0, etc. So overall, during this 2 years period, arms recovered 2 and ammunitions recovered 3. Arrest 7. There is not a single killing for last 2 years, up to 2022. Of various districts, Baska, Sirang, Kokrajhar, Udalguri, 4 districts. Next page, for 10 years data. Year-wise violence of NDFB since last 10 years in Assam. Their activities was not only involving BTC area, it was throughout the state of Assam. From 2012 to 2022, we have given total incidents 398, extremists arrested 2,108, extremists killed 154, civilian killed 179, security force killed 5, total persons kidnapped 72, total arms recovered 945, total ammunitions recovered 14,682, etc. And valuation of cash also is given, exclusive, etc. So how the things have changed after signing of the third Bodo Accord. So we have to look into the ground realities whenever we are examining a particular arrangement. What is this accord? This is purely a political agreement involving the government of Assam, central government, and the persons who are at the helm of affairs in PTC, who have a representative capacity, including BPF. BPF was a part of this exercise. Their leader number 1 was a part of the signing. 2, 3, and rest are now filing this petition. I will not say that that is a internal indiscipline. I'm not making any comment on that. But the thing is that those who were at the helm of affairs from 2005 to 2020, the BPF government, they were part and parcel of this whole exercise from 2013 onwards, till culmination of signing of the agreement on 27th of January 2020. And the leader, the CEM BTC, was present there. He was a witness, just like the Chief Minister of Assam and one of the Cabinet Minister of Assam. So this violence profile very clearly establishes from the data that after 2020, after January 27, almost zero. There is no action. There is no incident, no event of any violence there. Why will Lordship interfere now? They want Lordship's interference. They have to justify that people are really offended. Like, take the Lordship may kindly take the example, just 1 second. That the agricultural laws. Huge violence erupted in Haryana, Punjab, and Delhi area, suburbs. And the central government immediately made a suspension of the act, which was passed in the parliament. In those situations, Lordship, it is acceptable that a new law has been brought. It has created large-scale dissension. Then the government will act. But here, the things is just reverse. What is the outcome of this tripartite agreement? More investment. Foreign players, national players are playing. Development of industry, development of sports infrastructure, development of educational institutions. Nobody is unhappy, except few gentlemen of 95 persons before this court. So may I conclude now, Lord? Could it be some other day, Lord?
Yes.
I'm highly obliged.
Maybe today we can conclude. We've got.
Yes, because I have to show a lot of judgments also.
Lordship's convenience can be done tomorrow. Second half, subject to your Lordship's convenience. Can you have it on Thursday, 22nd?
From Thursday onwards, I am not available this week. From
Okay.
Thursday till Wednesday, I am available, Lordship.
We'll have it on Wednesday. Wednesday, then we'll have.
Wednesday, 2 o'clock, Lordship.
Or let it be at 10:30 so that we can
Yes.
finish it off on
Yes, or
Wednesday.
if it starts at 10:15, Lordship, I can
We
finish.
can finish it up on Wednesday. It's harsh on our lordship.
Maybe 2 PM be better because see, there's a class single and division.
I understand, Lordship. Only issue that it will spill over to some
Therefore,
other.
It is going to spill over.
So therefore, if we can start or subject to your lordship's convenience, we'll try to conclude it on Wednesday. That is the only concern because it is also not fair on the court that lordships will have to every time assemble. So if we can do it in one shot. So therefore.
So
that-
what
that
I
is
can do, Lordship, if Lordship takes up at 10:15, I'll try to wrap up by 12:15. Then 45 minutes they will get.
Sufficient for us to reply.
Then at 1 o'clock it will be over.
Yes, yes. that's
I'll
what-
also arrange my
Ah,
submission.
That's perfect.
And you can submit your written submission.
Yes, we will do that. Once.
Written submission, I will later on, Lordship. I'll
once we
submit.
finish.
Once we complete.
But Mr. Enigo Famil and the copy. So far, the title. The advocate general. Mr. Architect Chaudhary, the Deputy Solicitor General of India. And Mr. R.K. Asaraba. The standing counsel. Part in part, list for further hearing on 21st at 10:15.
I'm so good.
Highly obliged.
The matter on 29th of this month, madam, along with the IM, madam.
On request made by Mr. S.K. Matil and TSJ, list on 29.
29, madam.
Yeah.
Along with the IM. madam.
That will come.
Yes, madam. I will.
May be please, Your Worship. I beg to mention item number 16. As Mr. Engaged Council's item number 16.
Hmm.
Engaged Council's brother is in hospitalized, so my lord may fix a date in the month of March, my lord.
Who's the engaged?
First week.
Who's the engaged?
H. Hittia, my lord.
Yeah, sir.
On request made on behalf of H. Hittia and the council for the
My
petition.
lord may fix a date, my lord.
When?
First week of March, 4, 5, 6, 7, 8, date.
4th. No,
4th of March,
make it 11th. 11th March.
11th. Deputy.
My lord, this matter will come for orders, my lord, this on 29, my lord.
Why 29?
My lord, this is regarding the promotional, or any other date, my lord, on 4th of March, my lord.
Yes, 4th March.
I beg to mention item 50, my lord.
Item?
50, 50, last orders matter. It's a review petition, my lord. It may come, my lord, on 28 or 29, my lord. Maybe
Item 50.
50, my lord.
On request made by P. Forecastle and the council for petitioner. When do you want?
29, my lord. Or 28 as your lordship.
Okay, list on 29.
Obliged, lordship.
May it please, your Lordship. Lordship, I beg to mention item number 30, Lordship, 30, Lordship.
Yes.
Analysis of logas matter, Lordship, listed in 28, Lordship, 28 February, Lordship.
You are Mr.
S or my Lordship. Analogous matter, Lordship, WPC
On
9,
request made by A. Sharma, London Council for petitioner. List on 20,
28 February, Lordship.
28 February.
Lordship, WPC 9441,
Along with WBC number.
the 9441, 2019.
Yeah.
March.
My please, Your Lordship. Your Lordship, I beg to mention item number 36. Senior counsel could not afford due to some personal difficulties.
Who's your senior counsel?
Did not. Lordship, matter please be taken on 21st of this month.
Who's appearing for petitioner? Have you taken the consent? You take the consent from the petitioner's counsel. Then come back. I'll adjourn the matter.
May I please, Your Lord? My lord, I beg to mention the read petition for listing, my lord, in the motion column, my lord. Similar matter is fixed on 21st, my lord. Similar case, my lord.
Okay.
Obligement.
Your Lordship, I beg to mention item number 14,
1-4.
14.
Yes.
Your Lordship, the matter may be adjourned for the day as we need 4 weeks time to file our affidavit.
That's it.
Who's for petitioner?
I'm for the petitioner, Lord.
Yes,
That's it. 4 weeks will be too long, Lord.
yes. I'll give you 3 weeks. You're Mr.
Didas.
Third D does, Learned Counsel for petitioner. Mr.
J. Coletta,
J. Kalita, Learned Counsel appearing for response numbers
5 and 10.
5 and 10 is allowed 3 weeks time to file counter affidavit.
Lordship, maybe please to fix a date.
14th March.
Lordship.
Please, your lordship.
Mm.
My lord, item number 28, your lordship. Kindly take after 2 weeks, your lordship.
Yeah, Mr.
RM Chaudhary.
On request made by RM Chowdhury, Learned Counsel list of the 2 weeks.
Yes,
May it please, your lord. With the due permission and the consent of the other side, I beg to mention item number 15 of the daily list, my lord.
Item?
Item number 15,
Yeah.
We have received our instructions, my lord. 2 weeks time may be granted to us.
Who
File
appears
affidavit.
for the petitioner?
Well, D. Gogoi, my lord. I have his consent, my lord.
Okay. You are Mr.
H. Borua.
Mr. H. Barrow, Learned Standing Counsel.
No, my lord, I'm appearing on behalf of B. Gogoi, Standing Counsel. Finance and
Learned
Taxation
Counsel
Department.
appearing on behalf of B. Gogoi, Learned Standing Counsel, Finance and Taxation.
My lord,
How much time?
2 weeks time may be
2
granted.
weeks time is allowed to file contract. List up to 2 weeks.
Highly
May
advised.
may it please, your lordship.
Uh,
I beg to mention item number 42, lordship. In this matter, lordship, steps has been taken and it is returned with a note that Minal Hazarika,
wait for your turn, this one.
lordship.
May I please, lordship?
Uh.
I beg to mention for listing, lordship. For hearing, lordship, any convenient date,
5th March.
5th March. Much obliged.
May I please, your lordship?
Hmm.
Your lordship, I pray for listing of a matter, your lordship. Your lordship, in this matter, your lordship, the petitioner had submitted a report, your lordship, wherein he had investigated the matter. But the State Police Accountability Commission had remarked that there was no explanation as regards to delay while submitting the report. There is an urgency, your lordship. Pleadings have been completed, your lordship. Let the matter be fixed on 23rd of this month, your lordship, for admission. Much obliged, your lordship.
May I please, my lord, I beg to mention item number 49, my lord. In this case, my lord, respondent has filed affidavit in opposition, my lord. Kindly grant some time to file affidavit in reply, my lord.
Which respondent has filed affidavit in opposition?
Respondent number 7 earlier filed, today, my lord, respondent number 6 today filed.
So you want to file reply
Reply, my lord.
to respond number?
Respondent number 6 and 7. I'm for the petition number.
You are Mr.
M. Hussain. I am appearing on behalf of Mr. P.K. Roy Chaudhary.
Mr. M. Hussain, Learned Counsel, appearing on behalf of Mr. P.K. Roy Chaudhary, Learned Counsel for the petition is allowed. How much time?
2 weeks, my lord.
2 weeks time to file reply to the counter filed by the respondents, 6 and 7. List of the 2 weeks. Yes.
Most obliged.
May you please, your lordship, I beg to mention item number 33.
Hmm.
The conducting council having some difficulties.
Who's your conducting counsel?
Mr. S.P. Chaudhary.
Can request made on behalf of SP Chaudhary, Learned Counsel for petition. When?
After 2 weeks.
After 2 weeks.
Retabulous.
Item 1 for motion.
May I please, lordship?
Uh,
This contempt petition is preferred due to non-responding the order dated 12/11/2020 in WPC number 3392/2000. Despite the receiving of representation dated 10/12/2020 by the respondent authority. My humble prayer before your lordship to issue notice.
Where's the order? Page 8.
Page 8,
This is of 2020.
2020.
What's the limitation period?
Lordship. We have filed due time, but we
You're
are
filing your contempt when? 2021.
2021, Lordship. Due to some technical problem, the registry is not listed the matter. We have
When did you file in 2021?
we have filed additional affidavit also to annex the receipt of the postal.
When did you file this? Contempt.
21 lots. 2021.
Okay. But Mr.
Bika Clary.
Then the council issue notice. Is the petitioner still in the same, respondent in the same post?
I think
Senior
respondent
Superintendent of Police.
Superintendent of Police that time I was working as a SI at Karbi Anglong Lordship.
Anybody, Karbi Anglong, standing counsel. You better check up whether the respondent is still holding the post of Senior Superintendent of Police.
Man is, I think, sense, I think.
Then you'll have to change. You verify.
Lordship.
You verify the address incumbent.
No, I was working at under
I'm asking
SP.
you the address, this respondent number 1, the sole respondent, is he still holding the post of Senior Superintendent of Police?
The person, I think, maybe sense, but I was working under Senior Superintendent of Police Karbi Anglong that time.
That's fine. But
Lordship.
the person will name has to, this is by name, isn't it?
Lordship, you are correct, Lordship.
Then
Yes.
you verify whether the Senior Superintendent of Police has been transferred out, new incumbent has come in.
Lordship, Lordship.
If new incumbent has come in, whether
Lordship.
whether you have notified this new respondent, after that only content will come.
Lordship.
Cancel the order. When do you want?
Lordship, 1 week later.
On request made by Mr. Singh. So then you verify the address.
Lordship,
These are basics. This is a 2021 contempt petition.
Lordship.
Now it's 2024.
Lordship. Demobilize, Lordship.
Item 2.
None appears for petition. List after 2 weeks.
3.
May I please? My lord, the order at page, my lord, 13. And my lord, operative portion, my lord, page 30, paragraph 25. My
1
lord,
minute, 1 minute.
direction number E and F, my lord.
Page
Operative person 30, my lord.
30.
30. My lord, paragraph 2, there are several direction number E and F.
Yes. Then
My lord, not complied yet, my lord. Of course, there was some official communication among themselves, my lord, page 41, 42, 43. Of this communication was there, but my lord still not, my lord, compliant. Page 41. After receiving the High Court order, your lordship additional chief engineer wrote to the chief engineer. Page 41. Then my lord, government also wrote to the chief engineer. Page 43. They are very much aware about the High Court order, my lord. They themselves mention it. And page 44 is also, my lord, that is communication dated 1/2/2023. The additional chief engineer to chief engineer.
Have you filed your affidavit?
Yes, my lord, I have filed. I have filed.
This is also barred by limitation, isn't it?
My lord, I have, my lord, 215. That was the submission before this earlier courts number, my lord, 5. That is why, my lord, I was directed to file affidavit. Because, my lord, after communication, my lord, I hope that they will comply, my lord. And that is why, my lord, there is some delay. Because they themselves, my lord, communicated from the officer to officer. And that is why I hope that, my lord, it will be complied. But ultimately, since not complied, my lord, on my submission, my lord, I was directed to file, my lord, this affidavit. And in page, my lord, 5 of my affidavit, I have stated. And under 215, my lord, your lordship, my lord, inherent power, my lord.
But so and so learned counsel. You good name?
Yes, Chauhan, my lord.
Yes, Chauhan. Issue notice. Petitioner to take steps for service of notice on all the respondents by registered procedure within 1 week, list after 6 weeks.
What?
4 and 5.
My lord, sorry, item number 2, my lord. It has been passed over for 3 weeks. It became infructuous, my lord. The order has been complied with.
Item 2.
Yes. It may be closed as.
Item 2. Cancel that order. Your SK Ghosh.
Yes.
Mr. SK Ghosh, learned counsel for the petitioner, submits that the matter has become infructuous. Inasmuch as the respondents have complied with the order passed by this court. Stop. Accordingly, contempt is closed.
May I please? Your lordship, order annexer B, page number 12, lordship, non-compliance of the state, your lordship, honorable court order. So I have filed present contempt.
Yes, have you got
The government has filed an appeal, madam, against the order, madam.
any order passed in the appeal?
There is a delay, madam. Delay has been condoned, madam. He is appealing in that case, madam.
Delay has been condoned by the honorable division bench, lordship, but same has been pending, lordship. So, lordship,
Appeal has come up, not yet.
No, but not come up, madam. It will come up again.
So, lordship,
Because the delay has been condoned, madam.
So delay has been
until and unless it has been stated by the honorable division bench, or either Supreme Court, your lordship.
That is correct, but let us see what is there in the writ appeal.
Lordship, for the time being.
Mr. M. Saikel, learned counsel for the petitioner. Mr.
SP does.
SP Das, learned counsel for the respondents.
3 and 4, madam.
3 and 4 submits that delay has been condoned in the writ appeal preferred by the respondents, and The writ appeal is to be listed very soon. Stop. Accordingly, list this matter after 3 weeks.
Hello, my lord.
Item 6.
May it please your lordship, the petitioners has filed this contempt petition for willful deliberation of the order dated 9/1/23 passed in WPC number 294/20 lordship.
Page.
It starts from page 22 lordship. At this stage, notice may go lordship.
When did you file this appeal?
I have filed this contempt petition on 9/1/2024 lordship. And order was passed on lordship 9/1/2023 lordship.
Okay. But Mr.
P. Bordley lordship.
P. Bordley, Legal Counsel for petition, issue notice. Petitioner to take steps for service of notice on the respondents by registered post ID within 1 week. List of 6 weeks.
Oblige your lordship.
7.
May I please, your lordship? The order of this honorable court lordship is at page 11 and relevant is at page 13. Last paragraph, lordship. There is a direction to dispose of a representation within 15 days, lordship. That has expired, but has not been disposed of.
Within
15 days, page 14.
Okay, heard Mr. M. Ghan, Learner Counsel for the petitioner. Issue notice. Petitioner to take steps for service of notice on the sole respondent by registered post ID within 1
Well,
week.
in the false list, my name has not been shown, lordship.
List
That may,
matter after 6 weeks. Registry is also directed to reflect the name of Mr. M. Khan as the learned counsel appearing for the petition.
my lord. Oblige.
Item 8.
May it please, lordship, senior counsel, Mr. M.K. Sodhi is on legs. My lord, may be passed over the day, my lord.
For the day.
My lord, may be pleased to fix it on Friday, if my lord.
On request made on behalf of M.K. Chaudhary, Learned Senior Counsel for petitioner, list on 23rd.
Much pleasure.
9. Item 9.
None appears for petitioner. List after 2 weeks.
Item 44 from supplementary list.
Yeah, please, my lord. The recording there statement that appointments have been made to the post after filing of the repetition. I may be given the liberty to withdraw, my lord, with the liberty to approach again, my lord, incorporating the selected candidates.
We have already forwarded the
Names.
The names have been forwarded to me.
Yes.
MS.
B. Bora on behalf of Mr. A.K. Bhuyan.
P. Bora, Learned Counsel appearing on behalf of Mr.
A.K. Bhuyan for respondent number 1 and 2.
A.K. Bhuyan for the respondents 1 and 2.
1 and 2.
Submits that the appointment order has already been issued to the private respondents. Stop.
No, my lord, private response I had not made, my lord, to selected
Have already
candidates.
been met with the selected candidates. Okay. Stop. Mr. R. Majumdar, Learned Counsel, press for withdrawal of the suit petition with liberty to file afresh. The petition is dismissed on withdrawal with liberty as expected.
Man.
Mobilize.
45.
Your Lordship. The matter relates to regular family pension and other service benefits, Your Lordship.
Yes, employment, craftsman, who's happening? Family pension.
Family pension.
It's 43, Your Lordship. It is forwarded. It's shown.
Page
43, Your Lordship. 14 July 2023. Secretary forwarded to the director. It's 43. 43, Your Lordship. Dated 14/7/2023.
You have any instructions?
No, my lord, we have not received any instruction.
Then you receive instructions.
Notice please issue, my lord.
Third, Mr.
Assistant.
Yes, Islam and Council for Petitioner issue notice. Mr.
This is suitable. I am appearing for approval 1.
Here, Leonard, additional senior governor.
1 and
Paid
4.
correspondence, 1 and
4.
4. And director employment,
Madam, 2 and 6, madam. I'm appearing.
Mr.
SP Das, madam.
SP Das, then the standing council. Employment and craftsman training appears for correspondence, 2 and
6, madam.
2 and 6. Mr. R.K. Talukdar, Leonard standing council accountant general appears for response number 3. Finance,
D go away, my lord. His name may be recorded.
Mr. D. Gogol.
He will provide copy, my lord.
Standing council. Chalia is coming.
Sorry.
Chalia, you are here?
Yes, madam.
Okay, Chalia, then the standing council, finance. Appears for respondents, 5 and 6, 7. Notice and respondents are complete, however, extra copies will furnish the so and so. Respondents are allowed to file their affidavits. List after 4 weeks.
4 weeks.
46.
May I please, Your Lordship? My lord, in this case, my lord, petitioner has challenged the selection of a private respondent 5 as Gaubura, my lord. And in this case, my lord, after filing of this application, my lord, one notification I have received, my lord, where is there is some alternative remedies available, my lord, kindly have a look.
That section
162, my lord, amended section 162C, kindly, my lord. Executive instruction. Executive instruction, my lord. So
appeal.
Appeal. And we are apprehending, my lord, the private respondent apprehended, admittedly, my lord, the violation of the terms of the norms of the advertisement, my lord. There are 2 conditions laid down in the advertisement, my lord. So,
Then you approach the appellate for
yes, absolutely, my lord, and only hindrance, my lord. And in the meantime, before approaching the appellate authority, my lord, by private respondent might be given appeal, which is observation, lordship, so that within 7 days, we'll prefer.
I'm not making.
My lord, then by submission, my lord, within 7 days, we may be allowed to prefer an appeal before the.
That is up to you. You can just withdraw it with liberty to file up.
Well, some observation so that but there is an urgency in this matter. Otherwise, they will not keep it.
I'm not giving any.
Otherwise, my lord, they will not consider application. Even, my lord, by this notification recently changed the authority concerned.
Petition, that's a different thing. If you want to withdraw and approach the appellate from you, you get a stay order from the appellate.
Thank you. Thank you, sir. My lord, my learned friend is under similar situation. This honorable court response one judgment, my lord. Kindly have a look. Recently, I have got, my lord, this order, my lord.
Where is the order?
My lord.
What order?
My learned friend just is supplied to me, my lord. Yes. This one. Yes, my lord, similar direction, my lord. Alternative, you can check up the preparation. Yeah. Thank you. And until such time appeal is discovered, no order appointment be issued. This is the order, my lord. Passed by the Honorable Court.
Who are you?
I haven't sure participated also, my lord.
Also
Participated, my lord. I am the son of a Gaubura, my lord. But admittedly, the private respondent is not belong to that family of the Gaubura as well as, my lord. I have complied the conditions of the advertisement, my lord. Close 12, my lord. That advertisement, lordship will find at page 17, my lord. Page 17. And I'm relying next page, page 18, close 12.
Notice.
Advertisement it is, my lord. Notice, yes, notice. Next page 18, my lord, close 12. The applicants who are from the family of Gaon Pradhan will be given preference and remarks from the Mojada will be considered. There is a Mojada certificate is also in my favor, my lord, at page 26 and Annexure 6.
Page
26, Annexure 6. As per the conditions of the notice, my lord. This is issued by Mojadar, Pukwa, Utpal Chakraborty, Munindra Hale Sarup's previous Gao Pradhan, namely Soencho, Bhubaneswar Hale, Paschim Nalbari Soencho. During the period of ill health of the Gao, Sri Munindra Hale rendered his service in place of his father, continued to work in affairs of the Gao Pradhan. It is based upon knowledge that he bears good character. This is the certificate issued to me by the Mojadar as per the demands of the notice, my lord. Next, lordship, kindly have a look. Page 28 and Annexure 7. This is the call letter to me for interview of the post of Gao Pradhan. Then I appeared, my lord, and I have
Where's the select list?
page 30, next page, very last page, Annexure 8, my lord, serial number 18. Pangao lot number 1. This is private respondent Binut Haloi, my lord.
When was this issued?
I'm not selected. The private respondent Binut Haloi is selected for Pangao village, my lord.
Okay.
One, there's disparity is there with the case which my learned friend has said. Here there was a much delay when he came to the court and then the court passed an order. So the logic was that if you have not appointed a Gaambura for a long time, then very much we can stay for 1 more week. That's not an issue. That was what was.
So this is what the court is going to say also. If you have not appointed, wait for 1 week. But Mr.
Take it.
P.K. Degal and counsel for the petition.
Thank you.
Stop. Pursuant to a notice dated 26/5/2022 issued by the District Commissioner Nalbari for appointment of Gaon Pradhan in 101 vacant posts under revenue circles of Nalbari district. The petitioner, who is the son of the previous Gaon Pradhan, correct?
Yes, my lord.
Of
Bhubaneswar Haloi,
of Panigaon lot number 1
my lord.
applied for the said post. Stop. However, in the result that was published on 9/2/2024, the private respondent, namely Binod Haloi,
My lord.
was selected. Stop. The petitioner, relying on clause 12 of the notice dated 26/5/2022, stakes a claim for the post of Gaon Pradhan of Panigaon lot number 1, which provides that applicants who are from the family of Gaon Pradhan will be given preference and remarks from the Mojada will be considered. Stop. The petitioner also places reliance in the what is the certificate?
Yes, my lord. Certificates, page 26.
The certificate issued by the Mojada, Mauza Pukua, dated 8/6/2022, which has been issued in favor of the petition. So, Mr. Your good name, please.
Yes, Doctor.
Yes, Dr. Learned Counsel for the Learned Standing Counsel.
Standing Counsel. Respondent number 1, Revenue and Disaster Management.
Revenue and Disaster Management Department, / respond number 1. submits that in view of section 162-C
Executive instruction 162C.
in
Executive instruction.
in view of the amendment of section 162C, an appeal against the order of appointment, suspension and dismissal of Gon Pradhan by the district commissioner or by the principal secretary of the autonomous council shall lie to the director of land records
My lord.
and service Assam. Stop. Mr. P.K. Dekal and the council for the petition submits that he may be given liberty to approach the appellate forum in terms of section 162C of the executive instructions under the Assam Land Revenue Regulations, 1886 within bracket amendment 2024. However, he prays for short entry not to appoint the respondent number, not to appoint the private respondent till he makes an appeal within a period of 7 days from today. Stop. Recording the submission made by the land council for the petition. This writ petition is dismissed on withdrawal. However, with liberty to approach the appellate for stop. It is also provided sub para that if the private respondent Shri Binod Halu is not appointed, the same shall not be appointed for a period of 1 week, within which the petitioner shall refer his appeal. So, with the aforesaid directive.
My lord, here it is that while deciding the appeal, the respondent 3 may also give an opportunity of being heard to the respondent of 5.
That is a different thing.
Yeah, I'm
So-
on number 2, 3 and 4.
Mr.
CS Hazarika.
C.S. Hazarika, Leonard Standing Council,
Government.
Government Advocate appears for respondents
2, 3 and 4.
2, 3 and 4.
Applies.
47.
Maybe losses. Matter pertaining regarding the selection and appointment of the governor. Same, my lord. Same issue, my lord. Issue and same district also, my lord. And the petitioner is the son of the ex-governor and Mujadar also recommended, my lord. I
Where is
realize,
the notice?
my lord.
Notice.
Yes, my lord. Page, my lord, Gaubra recommendation and ex-Gaubra son, my lord, annexed, my lord. Page 16. Use the sons of the
This
ex-Gaubra.
notice is dated what? Advertisement.
Advertisement, my lord, page, my lord, 18. Notice, my lord.
This is dated what date?
Date, my lord, 26/5/2022, my lord.
Huh?
26/5/2022. Same, my lord, same jurisdiction, my lord. Date is same and my lord, selection list, my lord, page 51, my lord. Serial number 2, my lord. This is the lot, Badani Akhia, private respondent Anwar Hussain, my lord. That
Give me that, bring that file, that earlier file.
yes, Munwar.
So that one notification was there, no?
This is the Borkhetri Avenue Circle, my lord.
You are relying on the same one.
Same, same notification.
Serial number 2.
Yes, my lord. Serial number 2.
And where is the Gonbara certificate? Mother.
Yes, my lord. Recommend me Mother, my lord. Yes, my lord. 24, my lord. The applicant Fazul Haq is the permanent resident of Badani Akhya, Borkhetri. He is the eldest son of the retired Delhi headman, earlier governor, my lord. and being the son of the retired village headman, since the applicant helped in doing the activities in the village as well as Moza.
Yes,
Same or similar order may be perfect.
but Mr.
H. Ali, my lord.
H.
Ali, my lord.
Ali Leonard Counsel for the petition. Stop. Same order pursuant to a notice dated 26/5/2022 issued by the District Commissioner Nalbari
Yes, my lord.
for filling up 101 vacant posts of village footmen under various revenue circles of Nalbari district. The petition applied for the post of for lot Batani Akhaya. Stop. The petitioner places reliance to clause 12 of the notice dated 26/5/2022, which provides that preference will be given to members of the family of the village hetman, and the opinion of the Mauzada will be considered in this regard. Stop. It is the case of the petitioner that the Mauzada Parketri Mauza issued a certificate in favor of the petition in his favor. However, when the results were declared on 9/2/2024, the name of the private respondent, namely Manohar Hossain, was selected instead of the petitioner. Stop. It is the claim of the petitioner that he is the son of the ex-Gonbura.
Yes. Gaubura, yes.
Gonbura
Yes, my lord.
of Batani Akhai, of Lord Patani Akhai, and therefore he should have been given preference. Stop. Para, Mr.
As Doctor.
S. Datta, Leonard,
Standing
Standing
Counsel.
Counsel,
Revenue and Disaster Management Department.
Revenue Disaster and Management Department, submits that by the executive instructions under the Assam Land Revenue Regulations 1886 within bracket amendment 2024. The executive instruction 162-C has been amended, which provides for an appeal against the order of appointment, suspension, and dismissal of a gone prathan by the district commissioner or by the principal secretary of the outermost council area shall lie to the director of land records and survey Assam within a period of 60 days. Stop. Para Mr.
H. Ali.
H. Ali and the counsel for the petitioner. Prays for withdrawal of the present with petition with liberty to approach the appropriate forum.
See, as per what there is liberty.
With the prayer. Stop. He further submits that an interim order may be passed to permit not to appoint the petition, the private respondent, namely Manohar Hussain, provided the petitioner files the appeal within a period of 1 week from today. Stop. Para recording the submission made by the learned counsel for the petitioner. The suit petition is dismissed on withdrawal with liberty as prayed for. Stop. It is also provided that if the private respondent, namely Manohar Hussain, has not been appointed, no appointment order should be issued, provided the petitioner approaches the appropriate forum by way of an appeal within a period of 1 week from today. Stop.
Melody appointment will be kept in.
Here I am for respond number.
Okay, Mr.
C.S. Hadorika.
C.R. Zarika, Learned Government Advocate, appears for respondents.
1 and 2 I am happy.
Item 10 for admission. Item 10.
Your Lordship, last three occasions the petitioner didn't
None
appear.
appeared for the petitioner. None appeared for the petitioner. On 25/4/2022, comma 31/5/2022, and 6/10/20, comma 6/10/2023, and 17/10/2023. Today, when the matter is called up, none appears for the petition. Stop. MS.
K. Fukan,
K. Fukan, Learned Counsel, appears for respondents.
1 to 5.
You are the CG,
AGCL, Your Lordship, standing counsel.
Standing Counsel, ABTCL,
AGCL.
AGCL,
Yes, Your Lord.
appears for the respondents. 1 and 2, 1, 2, and 3.
1 is 1, 2, 3, 4. No, 1, 2, 3. 1 to 3, Your Lordship. 1, 2,
1,
and
2,
3.
and 3. Stop.
I may pay for respondent number 6.
And Mr.
T. Chakravarti.
T. Chakravarti, Learned Counsel, appears for respondent number 6. Which petition is dismissed for non-prosecution.
Obliged.
11.
Yes.
Yes, Lordship, regarding arrears salary, they have admitted it, but there it has not been cleared, Lordship. There in their affidavit, Lordship, the statement is there. I think it is.
Farah.
Affidavit filed by respondent number 2 to 5. Last page. Page number 6, 7, 8. Page number
Page
8.
Annexure R2.
Yes, my lord.
Yes, what do you say there?
My lord, we are facing my lord financial crisis, my lord. Last 20 months, my lord, no salary to the regular employee, my lord. So,
You have retired.
yes, retired.
So he expired, Lordship. His wife is before the honorable court.
My lord, we have submitted proposal to the government, my lord, for financial aid, my lord.
Where is that proposal?
Yes, my lord, we are annex, my lord, annex R1, my lord, page 7, my lord.
It's 2019.
You are harping on a proposal sent in 2019. Have you sent any fresh proposal?
This page always said, my lord.
Where is it?
That my lord, here it is, we have an annex, my lord. And last, my lord,
Show us the proposal.
last
You
year.
can't let someone suffer like this. Someone who died in 2000. When did your husband die? 2011.
No, but it is
No, no.
2016.
2014. On 17/11/2014, her husband died.
Yeah.
Then since May 2011 up to the date of his death, no salary. How can you do this? You'll have to pay with interest.
At present, my lord, we could not pay the regular salary.
Where is the proposal, recent proposal sent by you?
My lord, some time may be granted. Day after tomorrow, I'll put it.
You come prepared day after tomorrow?
Yes.
There'll be some coasters.
Yeah.
But Mr.
You doctor. You doctor.
You got his name? Learned counsel for the petitioner. On request made by Mr.
A. Zahid.
A. Zahid, learned counsel for the respondents, 2 to 5. List the matter again on. When do you want? 21st?
Yeah.
Item 12.
May please, your lordship. My lord, in this case, my lord, the petitioners were engaged as a pastoral workers and working since 1985. Lordship, may kindly have a look at the order at order dated 13/9/2023. The government advocate was asked to obtain instruction.
Yes,
So far, last order is concerned, my lord. We have not received the instruction, but we have received certain, my lord, document. The document says, my lord, the petitioner, they were not working except, my lord, 3%, my lord, a private respondent. These are the certificates, my lord. Lordship kindly see. Here, this certificate issued by the circle officer. He is working.
no, that we have seen in your affidavit. All right.
No, this certificate not annexed, my lord. This certificate,
Anyway, you have made the averments in your affidavit.
no, my lord, I have seen.
That you have seen. The only thing is we wanted to get some instructions. Why don't you get the instructions and come back?
That is not received, my lord. Only this certificate I have seen, my lord, that was
My lord,
in the affidavit.
My lord, this one code is to go by the instruction 13/9/2023. They are making here and there, my lord, they are not working that. My lord,
Another instruction which was received earlier, my lord, on May 2023. This also says, my lord, as per document, it is known that Ranjit Kolita and others were working as a wages earner, same men till 30th June 2017. But after 30th June 2017, they were unauthorized absent and did not physically.
That is of May 2023, isn't it?
Is May 23, my lord.
Have you seen the order of 13/9/2023?
That is after, my lord. That instruction is not.
That is what we are.
Sometime maybe granted, my lord, I would obtain it back.
Okay, heard.
We have written.
Council for the petition. The PC tutorial and the additional senior government advocate praise for how much time?
Well, 2 weeks time, it.
2 weeks time to enable him to receive instructions in terms of the order that 13/9/2023 passed by this court. Stop list after 2 weeks.
I am appearing for private response 7, 8, 9, 10.
Mr.
R. Islam.
R. Islam, then the council appraised for the respondents 7, 8, 9, and 10.
I am appearing for entry number 6.
Hmm?
6. Entry number 6.
MS
J. Boral.
J. Boral and council appraised for respondents.
Developmental.
17.
May I please, your lordship? On the last occasion, lordship was pleased to heard the matter. This is regarding, my lord, promotion of lecturer of dental, regional dental college, my lord. This is a covered case, my lord. I've referred to the order at page, my lord, 39.
Yes.
In this case also, the petitioner was, my lord, junior to the petitioner, but her case was considered, and my lord, with the similar circumstances, my lord. Because what happened, the petitioner was appointed as tutor demonstrator in the year 2006, my lord. In terms of the regulation, once they acquired the qualification of, my lord, MDS, they are entitled to promotion to the next higher post of lecturer, my lord. Here is a case, my lord, petitioner acquired his required qualification in the year 2017. His promotion was, my lord, order for promotion was issued in the year 2021, my lord. In the similar circumstances, this writ petition, the other writ petition, the order I annexed, the petitioner qualified her MDS degree in the year 2016, and her promotion was not considered. Accordingly, she approached this honorable court. This honorable court, by this order, my lord, directed the department to consider her appointment from the date of her acquiring qualification of MDS, and necessary promotion order was issued, my lord, pursuant to that. Paragraphs, my lord, page 42, paragraphs 11, page 42. The question that has to be decided is whether the post of lecturer as given in the notification dated 31/10/2011 is the promotional post of tutor, as can be seen from the chart provided in the notification dated so and so. The post of resident surgeons, demonstrator, registrator, or equivalent post, the above three equivalent posts have been redesignated into lecturer and tutor. The pay scale of lecturer and tutor is the same. The only difference is in the academic grade pay, where for lecturer it is 7,000 and tutor it is 6,000. The last column with regard to lecturer in the notification dated 31/10/2011 state that a higher level of AGP annual grade pay of 7,000 shall be given in the person entering the service with minimum qualification of BDS and having qualification of MDS, PhD, /MPhil. For tutors, the notification dated 31/10/2011 states that person joining the service without PhD, MDS, MPhil shall be appointed to the lower level of AGP of ₹6,000 and shall be eligible to the higher level of AGP of ₹7,000 after completion of 5 years. Here, my lord, petitioner was appointed in the year 2006, my lord. So he already acquires or acquiring MDS degree, PhD, MPhil, whichever is earlier. Thereafter, he also acquired, my lord, MDS degree.
When?
In the year 2017. It is further stated that a tutor would be entitled to a higher AGP if she completes 5 years of services as tutor. But if they do not acquire MDS, MPhil degree, their designation would continue to be a tutor. A reading of the provision of with regard to tutor and lecturer would thus go to show that the moment a tutor acquires the MDS degree, as in the case of the petitioner, the designation of the tutor would have to be redesignated as lecturer as she becomes being eligible for the higher AGP of the 7,000, my lord. The relevant extract of the notification dated 31/10/2011 is reproduced here in below, my lord. Column 5, my lord. This is relevant.
You are appointed as?
I am appointed as, my lord, tutor demonstrator, same, my lord. So my joining is in the year 2006. I acquired required qualification, and I acquired qualification in the year 2017. That is, my next promotion is lecturer, my lord. The shall be given to the person entering the service with minimum qualification of BDS and having additional qualification of MDS, MPhil. So in my case, my lord, I acquired MDS in the year 2017. So on the date I acquired the qualification, I am entitled to be promoted in the next higher post, my lord. And
Give me the date when you got your MDS.
MDS, my lord, I got in the month of 15/6/2017, my lord.
You are appointed as?
Initially, I was appointed in the year 2006 as, my lord, demonstrator. Demonstrator tutor, same, my lord. And the other read petitioner, she was appointed in the year 2009 as demonstrator. Then, my lord, I, as a my lord, demonstrator, I was allowed to continue pursuing my higher education, and accordingly, I joined, my lord, in the MDS course, and I qualified in the year 2017. 2017, my lord, I joined after completion of course, and my degree was, my lord, issued in the month of 16/8/2017. My lord. Then my case was forwarded time and again.
Degree issued on
16/8/2017.
MDS.
MDS.
Hmm.
Thereafter, my lord, Annexure 13, page 36. Relevant portion, page 37, my lord. Page 37, my case was forwarded, showing the vacancy position that after, my lord, after 4 years of my service as a lecturer, I am entitled for next promotion as reader, my lord. Page 37, column 2, 2 posts, one, my lord, occupied by Dr. Isha, the next one is vacant, my lord.
Where? Okay.
Then, my lord, in page 38, again, my case was forwarded by the Director Medical Education to the Commissioner and Secretary, Government of Assam. In the on 5/3/2022. In the other case, my lord, in paragraphs 16 and paragraphs 18, this honorable court, after considering everything, directed the department to, my lord, give her promotion from the date of her acquiring qualification and consequential benefit, my lord.
Where's the notification?
Notification, my lord, relevant exact is given in the order, my lord. Lordship, kindly see page 43.
No, in your writ petition.
Writ petition, that notification is not annexed. I have the copy, my lord. This is bulky, my lord, views around 200 pages.
Give me the relevant portion only.
Yes, I am giving just.
Bora, are you in the?
Yes, my lord, this is.
Is it the
My lord, he is claiming for promotion. So the promotion can be considered by the DGC, my lord. So his claim may be for consideration of his case for
That is that.
promotion. But this judgment is, my lord, this judgment is regarding, my lord, redesignation of the post of tutor, which is, my lord, if your lordship peruses page 43, the lecturer and tutor is same, only the grade pay is different. So she was as a tutor, so on her obtaining the MDS degree, she has been redesignated as lecturer. But here in this case, the petitioner is praying for promotion from the post of lecturer to reader, my lord. So that has to be considered by a duly constituted.
My lord,
my lord.
my lord, on that, my lord, lordship, kindly see page 45 of the order, my lord. The order, page 45.
Yes.
If my lord, redesignation was made from the date of my lord acquiring qualification, then I am entitled for next promotion only, my lord. And that is there, my lord. Page 45, paragraph 16. The letter dated 27/2020 issued by the principal in charge regional dental college Guwahati, which is addressed to the Director of Medical Education Assam, state that 7 numbers of teacher, of which 4 teachers are MDS qualified, including the petitioner, are to be redesignated as lecturer as they have obtained their MDS degree during their service period. The contents of the above letter dated so and so also show that the state respondent have interpreted the contents of notification dated 31/10/2011 to mean that tutor is to be redesignated as lecturer and not promoted. In this respect, though the request for redesignation has been made by letter dated so and so, issued by the principal in charge, RDC Guwahati, this court is of the opinion that redesignation would automatically have to be taken place from the date when the tutor acquires the MDS degree in terms of notification dated 31/10/2011, this is automatic. As the petitioner has rejoined the post of tutor on 24/8/2016 after obtaining the MDS degree, this court hold that the petitioner redesignation as tutor has to be redesignated as lecturer with effect from the 24/8/2016 as the petitioner became eligible for higher AGP of rupees so and so. From the date of her acquiring qualification, this promotion was allowed. In last paragraph, in view of the above reasons, this court directs the respondent authorities to count the seniority of the petitioner as lecturer in the RDC, Guwahati, in the Department of Pre-Dentistry with effect from 24/8/2016. From the date of her acquiring qualification, this was allowed, madam. Once my lord, redesignation was made from the date of my acquiring qualification. From 2016, I will be qualified for next promotion in the year 2021, my lord. 4 years, my lord. In terms of the, my lord, regulation.
Which regulation?
Just give me an idea. Okay.
This one?
Yes, ma'am. Lecturer, promotion দিতে lecturer দিতে ভুলকে দিলে February 2021. My lord, page 33. Page 30 of my writ petition, my lord.
Yes.
My promotion as lecturer order was issued on 23rd of February 2021, which should be, my lord, on my lord 15/6/2017, my lord.
Yes, my lord. In the post of a lecturer, that can be considered, my lord, in terms of the judgment, my lord.
Similar circumstances.
So this notification is wrong according to you?
Yes, my lord.
So you are impugning this notification?
Yes, my lord. It should be from my lord 2017, my lord. From the date I acquire, my lord, MDS degree, my lord.
So you acquired on 15/6/2017 or 16/8/2017?
16/8 I acquired, I rejoined in my original post on 15/6/2017. So it should be from 16/8/2017. In terms of judgment, my lord, 16.
Yes, my lord. That is covered, my lord. From the post of tutor to the post of lecturer, my lord.
It should be from the, my lord.
But not promotion.
Not promotion.
Promotion, my lord, subsequent once I acquired the promotion, once I acquired the qualification, redesignation in terms of, my lord, regulation provides that page 43 for reader, a reader who has completed 5 years of service in the
That is okay. So, my lord,
next
this pair number 1 may be considered page 16, my lord.
What do you say about the other prayers?
Other payers, my lord, subsequently, when he will become eligible for reader, my lord, the duly constituted
DPC will consider, my lord.
DPC will consider for promotion to the post of reader, my lord.
Here you said 15/6/2017.
Yes.
But then you are submitting at 16/8/2017.
16/8, my lord, my certificate was issued. After completion of my degree, I joined in my department on 15/6/2017.
According to you, which one should be the date?
Date from is 16/8, my lord. Because certificates were issued on 16/8. I have annexed it. Page 25.
Yes.
So for promotion part is concerned, my lord, once I acquire minimum qualification of 5 years in the post of lecturer, that will be considered by the DPC in accordance with law. That part will differ. So far, my redesignation of lecturer is concerned, that should be from the date of acquiring my qualification.
Yes, member. I'll pass.
Obliging.
This was.
Obliging.
Item 18, 19 and 20.
Me, please, Your Lordship, the case related to the petitioner was suspended under Fox Act, my Lordship. Today, I asked for adjournment, my Lordship, if Seniority engaged another court, my Lordship.
Who's his senior?
A P court, my Lordship.
On request made on behalf of Mr. P. Kataki, the counsel for the petitioner. Released after?
My Lordship, kindly fix on 21 March, my Lordship.
19th March.
19 March, obliged, my Lordship. My Lordship, writ petition 2961 is there is an interim order, my Lordship.
Interim order passed in WBC 2961 of 2022 to continue in the next suitable date.
Obliged, my Lordship.
21.
Affidavit has come?
No, my lord. Some time may be granted, my lord. Notice was issued on 27 January 2023.
1 year.
23.
Hmm?
We have said it, my lord.
They are trying to review the order that has been passed.
Are you sure?
State government. But we have no connection with review. Government want to review the order of the learned single judge, which have no connection or bearing with our case, man. No bearing, but they want to review the judgment. Because they thought the judgment which was passed by this honorable court, and on the basis of that, the government thought in a different way. And the notification which was issued, that was withdrawn. So by that notification, we get the benefit. But that notification was withdrawn. That was a post from LDA to sub-inspector in the Food and Civil Supply Department. The notification which was issued was at page 57. Kindly see 57. 28th of December 2021. It was addressed to all the principal secretaries. If you see at subject, fill up of vacancy of sub-inspector of food, civil supply, consumer affairs by promotion among the ministerial cadre thereof regarding. So it was promotion to the post of sub-inspector in food and civil supply department. Now there are certain criteria under the rules 11.2. If you see 57, they said that there is a rule, service rule 11.2. First paragraph, I am to inform this director is undertaking step to fill a vacancy of sub-inspector of food and civil supply and consumer affairs by promotion from the applicant belonging to ministerial cadre as per provision 11.2 of the Assam Food and Civil Supply Service Rule 1970 as amended in the Assam Supply Service Amended Rule 1989. So there are certain provision, at least 5 years of continuous service. If you see one, it has to be candidates should have completed at least 5 years continuous service in the ministerial cadre on the first day of year 1/1/2021. So we qualify as per rules. Now, why the problem started? The problem started at page 67. One of the candidate, one of the petitioner, not in connection, my lord, he appeared and he said, I doesn't belong to that ministerial cadre. I belong to the deputy commissioner establishment. So now the learned single just said that rule is not applicable who belong to the district deputy commissioner establishment. So anyhow, that rule will not be, that notification is not applicable. If your lordship kindly see at page 73 of the judgment, kindly see 73 of the order, para 12. in view of the above reason, it is quite clear that 1970 rules cannot come in the way of petitioner being considered for promotion to the post of sub-inspector, inasmuch as 5 years continuous service required in the FCS and CA department will apply to departmental officers. We belong to departmental officers and not to the employees working under the amalgamated establishment deputy commissioner. So though the petitioner who came to this court, he does not belong to the departmental department. He belongs to the establishment deputy commissioner. And they said it should also be noted that 1970 rules pertains to the members of the Assam Food and Civil Supply Department. And as such, the same cannot be said to cover the service condition of the employees under the amalgamated establishment of deputy commissioner. Further, the established deputy commissioner comes under general administration department and not the FC and CA. If you kindly see at para 70, page 75, 15, para 15, in view of the reasons stated above, this court is of the view that non-consideration of petitioner case for promotion from junior assistant sub-inspector by selection committee is arbitrary. Further, decision of respondent to not to give relaxation as reflected in the letter dated is also found to be unreasonable, unjustified. Selection committee meeting minutes dated so in so far as relate to petitioner letter dated so and so set aside. Respondent direct to convey review DPC to consider case of the petitioner. Promotion to the post of sub-inspector from the date when his immediate junior was promoted in terms of the next below rule. So he doesn't follow the rule. He came that why my case cannot be considered to the post of sub-inspector. Court said yes, he doesn't have, because there was no continuous, because he doesn't qualify that continuous 5 years of service. He comes to the court. He said, why? Not important, because I don't fall under that rule. Why that continuous 5 years of service? Learned Singh is a whole, yes, he doesn't fall under that rule. He doesn't belong to departmental, under that department. He belongs to district and establishment. Rule is not applicable. Please consider his case. Now, the judgment of the Learned Single was misinterpreted or misunderstood by the government. And what they does at page 77, where we are aggrieved and have come up before this court. Kindly see page 77. Page 77.
WT message.
WT message. In the light of the judgment order dated 31/3/2022 passed by so and so, which is regarding recommendation of eligible applicant for promotion in the post of sub-inspector from district subdivision as per then prescribed criteria may be treated as cancelled. The original service book and other relevant documents sent earlier through proper. So this is how we have denied. They have misinterpreted, misunderstood the judgment of the court.
Yes,
They have to take some step. And I have been told that they have reviewed this. They are trying to review the judgment. Anyhow, we are not concerned about that review. We are concerned about our promotion. And they clearly Learned Single just said.
2 weeks. At least 2 weeks.
Let them file it.
But Mr. D Das, then the senior counsel, assistant commissioner.
HK.
Stop. Mr. TC Tutor, then a petitioner senior government. Please allow 2 weeks to file. List after 2 weeks. Interim order is there?
Yes, interim order.
Interim order passed to continue till the next.
Quickly observe.
22.
May it please, Your Lordship. The minutes of the DLC is at page number 18, my lord. If Your Lordship kindly turns to page number 18. My lord, serial number 2 in the middle, my lord. Page number 18, my lord. Serial number 2. Name of the applicant, Sri Monikansan Das. He is the petitioner, my lord. And on the right side is the remarks, my lord. The remarks says, the committee observed that the applicant was minor at the time of the death of the government employee. Hence, he applied only after attaining of the required age qualification. The case is forwarded to the government for consideration as per norms against available vacancy for the year of 2015, my lord. So matter was sent to SLC, my lord. And SLC, Your Lordship will find, my lord, it starts at page 28. SLC minutes 2/8/2022.
Page
28, it starts, my lord. Relevant is at page number 31, my lord.
Page 31 on the right side, my lord. Serial number 9, my lord. Serial number 9, Monikonson Das. And on the right side, remarks. As per observation of the DLC, the applicant was a minor at the time of the father's death. So the DLC forwarded the proposal to the government for consideration. The SLC reviewed the matter and found that the candidate applied after 4.5 years of the death of the government employee. Hence, the proposal could not be recommended as the proposal does not fulfill the requisite criteria as per point number 3 of the OM number so-and-so dated 1/6/2015, my lord. And there are two recent rulings of this honorable court, which has provided that this criteria is only directory in nature. Those two judgments are
different thing. That is a different thing. But then see, he applied after 4 years.
At the time of the my lord, that
You
was
were
a minor. That is there. I'll just point out that before your lordship, my lord, if your lordship kindly takes up, my lord, starts at page 32, my lord, page number 32. And if your lordship kindly turns to page number 33, in fact, 34 is where the relevant paragraph your lordship will find. Paragraph 3, my lord, page number 34. It says, when the recommendation of the DLC made in the favor of the petitioner was placed before the SLC in its meeting dated 31/12/2018, it stood rejected by providing A as number 1, applied after 1 year from the date of death. Second is not necessary, not within 5% quota. As regards the first reason of having applied after 1 year from the date of death, it is an admitted fact that when the father of the petitioner died, he was a minor, and the application was made after attaining the age of majority by the petitioner, and therefore it could not be made within 1 year from the date of death. Further, the requirement of placing the claim of the petitioner within a period of 1 year is a directory provision as already held by this court in a number of judgments, and it is for the DLC to examine as to whether the family could overcome immediate financial hardship because of the death, or whether the family is still continuing in an acute financial crisis. Now, it discusses the second disqualification, which is not relevant for our case. And if your lordship kindly turns to the next page, my lord, this is what the honorable court did, this honorable court. For both reasons, the matter stands remanded back to the SLC for a fresh consideration. Similarly, my lord, the next ruling your lordship will find at page 37. Page 37, my lord. The facts your lordship will find, I'll directly come to the point, my lord. Page number, paragraph 3, it says, it is stated that admittedly the petitioner was about 6 years old when his father had died and he had made the application after attaining majority. Although decisions of the Honorable Supreme Court to the contrary are available, that a post of compassionate appointment cannot be kept reserved. But in Syed Khadim Hussain versus State of Bihar reported in 2006-9 SCC, it has also been provided that in the event an applicant is a minor at the time of the death and makes an application after attaining the majority, the same can also be given its due consideration. Accordingly, my lord, it was remanded for a fresh consideration. In my case, my lord, there's only one document which deserves your lordship's kind attention. It's a letter dated 18/2/2022, which your lordship will find at page 24, my lord. Page number 24. It's a letter which was written by the respondent number, my lord, 5 to the Deputy Commissioner, Jorhat. It says, 18/2/2022, sir, in inviting a reference to the subject cited above, I have to inform you that Shri Monikonson Das, that is the petitioner, died on so-and-so. Shri Monikonson Das applied for the post on compensation grant against the death of his father only after attaining the requisite age and qualification, but was rejected by the SLC. Now he has reapplied the same. In this regard, the letter of the commissionerate sent to the government under reference may kindly be referred to. In this regard, the latest vacancy position of different post of Central Jorhat Development Block Sapikola is enclosed. And next page, your lordship will find the vacancy status. Page number 25 and 26 reveals, my lord, there are ample vacancies. All I'm praying, my lord, limited prayer. Let them give me a consideration on merits, my lord. That is my limited prayer, my lord. That is my limited prayer before your lordship.
What is the object of compassionate appointment?
That is correct, my lord. But due to the, my lord, although 2015 I was recommended by the DLC, my lord, after that nothing concrete happened. It was only in the year 2022 on a technical ground I was rejected. That is my limited prayer, my lord. Rest is up to your lordship, my lord. Because from 2015, yes, my lord.
Possible, turn to page number 21 for the retreat. You'll also see the first column below A, the name Monikansan Das and date of birth 15/11/94. Which means that on 2015-11, 2012, he became major. So assuming that his argument that, okay, he was a minor, therefore he could not apply, that also if we take into consideration, it still means that from 2012, November 2012, he could have applied. But he did not apply and he applied only in 2015, Your Lordship. 16 to 2015, Your Lordship, after he became adult. This in itself shows that there is no immediacy. There was no, otherwise a person who is desperate for, he's not having any means of livelihood, he will apply readily, Your Lordship. And anyway, recently Your Lordship has possibly come across this case of the state of West Bengal versus Debabrata Tiwari, Your Lordship.
Sure.
Lordship, I can mail it to the Honorable Court and I'll write it.
You bring a hard copy. We'll list it day after tomorrow. Oh no, not day after. Next Monday, 26th.
Or your lordship can have it on 22nd also.
We'll have it on 26th.
26th.
22nd, many cases.
My lord, 26th. My lord.
30 on request made by Mr. C.
S. Hazarika.
S. Hazarika, government advocate, list on 26th.
Lordship, I am appearing for respondent number 4 in 5, Lordship.
MS.
J. Bora, Lordship.
J. Bora, then council appears for the respondents for
4 in 5.
URD.
PNRD, Lord.
Huh?
PNRD, my lord. Panchayat and rural level.
Standing council here.
Public.
23.
May I please, Your Lordship? Your Lordship, kindly the matter may be passed over for the time being, as my senior is on leg at C27.
High Court counsel will also be required, Your Lordship. Let it come some other day.
Okay. On my request made on behalf of MSR Chaudhary, then the council for petition. When? After 1 week? Released after 1 week? Yes.
24.
May I please, Your Lordship? Lordship, matter pertains to my lord compassionate appointment, my lord. After death of the husband of the petitioner, my lord, who was the constable, my lord, she has applied for the post, my lord, India 2011, my lord. 2010, my lord, page 18, my lord.
Your father died when?
My husband died, my lord.
Husband died when?
8/9/2010, my lord.
Then?
I have made application on 27/9/2010, my lord.
Then
Thereafter, my DLC, my lord, page 21, 17/11/21 and 18/11/2021. Page, my lord.
31.
Page 20, my lord.
Page 20.
Page 20, my lord, 17/11/2011, my lord, sorry. 17/11/2011 and 18/11/2011. My name is at, my lord, page 21, serial number 2. Bhavani Kolita, my lord. Serial number 2 in the top, my lord, page 21. The following application could not be considered due to overage, my lord. Thereafter, I have approached this honorable court, my lord, page 26, my lord, of this honorable court order, my lord. This honorable has disposed of the matter with a direction that the state respondent to reconsider the case of the petitioner for appointment under dye in harness scheme to any other post other than the lady constable where such age bar may not be applicable, my lord. Page 28. Thereafter, my lord, again my name has been placed before the DLC at page 31, my lord, on dated 30/09/2019. My name is at page 38. Serial number 2, page 38, my lord. This time, my lord, due to want of vacancies, it was rejected.
38.
Page 38, my lord. Page 38, serial number 2, my lord, Bhavani Kolita.
Bhavani Kalita.
Yes, ma'am. The proposal of the following candidate will be considered later, subject to the availability of vacancy, my lord. My lord, in the affidavit filed by the respondent authority, my lord, they have admitted that, my lord, my application has been proceeded, my lord, but did not place before the DLC yet, my lord. If the take up the, my lord, affidavit in opposition filed by the respondent, my lord, annexed
3, my lord, page 55, my lord. This letter says, my lord, the deputy commissioner has been directed by the commissioner of police, my lord, to place my name before the district level committee, my lord. In the second paragraph, if I may read, my lord, subsequently the Assam Police Headquarters, while later so and so, directed this office to place the matter before the district level committee, and after obtaining approval of the matter, has to be referred to state level committee for final approval of the appointment of Srimati Bhavani Kolita on compassionate ground. That is the petitioner, my lord, of grade 4 post. But they have not objected my claim, my lord, in the affidavit. My lord.
What is your stance, Chudya?
And my prayer is very
No, my
limited, my lord.
lord, it was placed in the DLC.
My lord, that
After
is my-
DLC, my lord, that was not recommended. It was rejected. And thereafter, my lord, 2019 minutes, my lord, is due to absent of my lord, vacant post, his case is pending. It is so far the that case is concerned, my lord. This court has, my lord, made out some principle. Principle, I think 10. 10 says, my lord, if it is pending for more than 2 years, my lord, it is spent post. That's why, my lord, on the ground also, my lord, the petitioner case cannot be considered. My lord, because
So when you made the consideration,
in 19,
you could have applied clause 15 of the OM, isn't it?
15 OM is there, my lord. But in 2019, also 2019, my lord, there is no post.
But any
If there
other
is no post in under, my lord, 55%, my lord, quota, then he cannot be appointed, my lord.
What does clause 15 of the OM say?
15 says, my lord, to any other department by the administrative officer.
Then
This is depend upon the administrative office, my lord. So,
my prayer is very limited, my lord. Even this objection is not raised in the affidavit in opposition also. My
no,
senior has.
objection is not, we have stated here, there is question of the objection not agreeable. We are not agree with them. Honorable Court had considered, so prayer also is in compliance with the action Honorable High Court, the headquarters of Dubai issued instruction regarding appointment of petitioner on compulsory ground on 21/1/19. In response to the Assam Police Headquarters was informed the non-availability of vacancy grade 4 and requested to consider for appointment grade 4 post in any other district. That's to ensure. Subsequently, the Assam Police Headquarters has directed to place the matter for the district level committee, and after obtaining approval, the matter has to be referred to. So only one instruction is necessary, my lord. So this letter he has mentioned here, my lord, this is placed before the district DLC and to send to the SLC, whether that was placed or not.
No, that is not my letter. That is the department letter, my lord. That is in the affidavit in
The
opposition.
matter will be come to an end. That
okay.
I will obtain
Mr. S. Hazarika
My
and Council. Mr. T.C. Tutil and additional press for a short time to enable him to receive instructions. When?
after 2 weeks, my lord.
Please stop to 2 weeks.
Obliged, my lord.
25.
May I please, Lordship? No, this is related to compassionate appointment, Lordship. Well, earlier I approached before this honorable court.
Balance 3 years judgment.
Well, already there. On 2 grounds, Lordship, my claim has been rejected. That is, your Lordship will kindly come to
Okay,
place.
the balance of 3 years.
That is one, and another one is there is no vacancy. Without disclosing the total number of.
That one, the order has been stayed. Yeah.
Well, not under similar circumstances, Lordship, this honorable court has already disposed of the writ petition, saying that as there is no stay order in the Lordship.
Now stay order is there.
Stay order is there.
Stay order.
Lordship,
Then
in
we
the
have to wait, Lordship.
First, Mr. M. Khan and then Council for the petition. Stop. No, Mr. S. Hazarika.
CS Hazarika.
C. Hazarika and Governor.
Goswami appearing.
1 minute. Submits that in the writ appeal filed by the respondents against the judgment dated.
Happy 1/2000.
31/20/23.
31/20/23 passed in WBC number
1646 of
21.
2021.
1646 of 2021
That is the leading case.
with
With
other batch of
My lord.
with other batch of writ petitions has been stayed by this court. Stop.
We have preferred an appeal on another case called Deepak Gogoi. That case, Your Lordship. That case number is
This matter after 4 weeks.
My lord.
Cooperation Department.
Mr.
RB Goswami.
R.B. Goswami and the Standing Council Cooperation, Standing Council appears for the Cooperation Department.
26.
May it please your lordship. Lordship, the matter has been practically infectious, lordship. The petitioner has already retired. Lordship may close the matter, lord.
You are Mr.
R. Deka on behalf of R. Majumdar.
Mr. R. Dekal and the council appearing on behalf of Mr. R. Majumdar, then the council for the petitioner submits that the petitioner has retired from service and the matter has become infectious. Stop. MS
B. Sharma.
B. Sharma, then the CGC appears for the respondents. The petition is disposed of as infectious.
27.
Please your lordship. My lord, last time it was for instructions from to be obtained by the forest department. Practically, they have conceded to the prayer in the writ petition.
But now everybody wants to wash their hand. So only limited instruction is this, that the VRS granted to the petitioner was found infected with anomalies. So judicial department's view was sought for, and we acted upon only upon the view. The judicial department views are sought for because certain anomalies were noticed in the VRS order of the petitioner. So only we had adhered to what the judicial department had advised us.
Well, the question is, 2012 the VRS was granted. Rightly or wrongly, VRS was granted in the year 2012. Now, after a lapse of 11 years, whether that order of VRS can be cancelled by the government. That is plainly, Lord, and this cancellation is done only with an objective to departmentally proceed against her.
Let us see when you granted VRS.
I was granted VRS by an order dated 2nd of November 2012, and the impugned order, your lordship will find that impugned order says that it was noticed to be irregular. How it is irregular and why it is irregular, and even if that be so, your lordship may kindly come to page 69. Page 69. Page 69, they say that so-and-so were joined as Wildlife Research and Education Officer on so-and-so as per order number so-and-so. The temporary post was retained by the government of Assam with effect from 1/1/2001. Whereas so-and-so was allowed voluntary retirement by government notification dated 2nd of November 2012. Whereas so-and-so had applied for her pensionary benefits. Whereas so-and-so was absent from her duties for a total period of 7 years, 3 months and 28 days. Whereas views of Finance Department was obtained and Finance Department observed that as per FR 18, the incumbent should have been removed from service after following due process. So the department requested to examine the case in the light of FR 18 and to ensure how VRS was granted in spite of the willful absence beyond 5 years and why department has prepared to regularize the period of absence more than 5 years. Whereas judicial department was obtained and judicial department by number so-and-so dated observed that since the present case VR was passed illegally and the same may be withdrawn and a fresh DP may be initiated for unauthorized absence so as to invoke FR 18 as advised by Finance Department and conclude the same in accordance with law. And therefore, in view of the above, Governor of Assam is pleased to withdraw the voluntary retirement dated 2/11/2000. Now, after 11 years of passing an order of voluntary retirement, can it be withdrawn like this?
Who is that order of VRS?
That order of VRS, your lordship will find at page 61. 61. In fact, my lord, I filed the application for VRS in the month of, I'm just giving a preface, my lord. I filed the application for proceeding on VRS in the month of February 2012. And as per the decision of this honorable court, which was upheld by the Supreme Court later, my lord, if for a period of 3 months it remains unrejected, then VRS is automatic. That is Dinesh Chandra Sangma's case, 1977, my lord, long time back.
Now, February 2012, I filed the application. They did not reject my application. So, following the dictum of Sangma's case, my lord, my VRS became effective in the month of May itself. However, my lord, regardless of that, they passed an order. Consciously, they passed an order on 2nd of November 2012. This is 61. And the last paragraph, your lordship may kindly see. The period of leave of absence of Srimati so-and-so will be regularized on the basis of leave admissibility report from the Accountant General, and from the period for which no leave is available, extraordinary leave will be granted. The pension eligibility will be decided in consultation with the Pension and Public Grievances Department. Now, this is following the provisions of FR, my lord, where because my absence from duty was on medical ground. That is also admitted. I contracted a disease, autoimmune disorder, for which I had to be taken to out of state. I had to be treated at Delhi, and I had to remain there. So that was the extraordinary circumstance on which the absence from service was occasioned. But since I was not getting fully recovered, therefore I submitted an application for allowing me to proceed on voluntary retirement. And the order is clear that if the leave is admissible, available, then it will be adjusted, and if no leave is admissible, available, then it will be granted extraordinary leave. There is a provision in the pension rules, my lord, to grant extraordinary leave, and on that circumstance, 2012, this voluntary retirement was granted. And it was observed that my pension will be decided as per the provisions of law. Now, this pension I demanded for pension. When I pressed the department for release of my pension and pensionary benefits, now they have come up with this. After a period of 11 years, keeping me deprived of the pension and pensionary benefits, now they want to say that this order should go, this order should be withdrawn, and a DP may be. Can it be logically possible, my lord? The moment I am allowed to retire voluntarily or otherwise from the service, the master-servant relationship between the government and the employee is snapped. Thereafter, how do you recall an order? And on what ground you are going to recall it? Merely, your lordship will kindly see, the order is also not a conscious order passed by the governor, because merely some department took an objection, some department formed an opinion that since there was a long period of absence, so she should have been otherwise punished, or she should have been otherwise removed. Therefore, this opinion is created. So this is also not an independent opinion of the governor. So therefore, noticing all these irregularities, my lord, this honorable court protected me by passing an interim order that after so many years, how can you now proceed again? Then what is the misconduct you are trying to formulate? The only allegation is that period of absence because of medical ailments. Now, consistently, my lord, everyone is now shirking their responsibility. The other department has said, Finance department has said that no, this AG has said that it is somebody else's case. Forest department is also now saying that it is somebody else's decision. So therefore, my respectful submission before your lordship will be, looking at the chart of events that has appeared in the case. Well, this order is ex specie arbitrary. There is absolutely no reason, and there is also no authority of law. If they want to recall an order of voluntary retirement, then it ought to have been done in the available time. After 11 years, you cannot pass an order saying that we committed some mistake and therefore we want to. And the mistake is also not spelled out. The lordship will kindly see, I have enclosed the provision of the FR 56. The only thing has developed because I demanded pension, nothing else. Because so many years, they remained settled. They were happy. Just after, because before this writ petition, I filed a writ petition, my lord. I have made a disclosure in this petition itself. I filed a writ petition demanding the release of my pension and pensionary benefits. Now, when this honorable court had issued notice on the matter, this writ petition was filed on it was dated 3/3/2022. Now, after I filed that writ petition, now this device has been created. Just to frustrate my claim for pension, nothing else. Your lordship will kindly see page 18, paragraph 23, I have stated. page 18, paragraph 23. That the petitioner situated thus had approached this honorable court through WPC number so and so with the prayer amongst others the follows. Writ of mandamus should not be issued directing respondent authorities to forthwith release the monthly pension of the petitioner along with arrears of monthly pension, death cum retirement gratuity, general provident fund and all other ancillary benefits with interest at applicable interest rates. Writ of mandamus shall not be issued directing the respondent authorities to consider the absence of the period deemed to be regularized in terms of notification dated so and so, 2/11/2012. After this, my lord, they have now come up with this order. And the provision, my lord, which says that that the FR 18 that they want to now refer, the FR 18 comes to operation when a person is in service. FR 18 is, my lord, I have enclosed in the writ petition itself. It is quoted, my lord, in the annexure. The extract is in the annexure. Your lordship will find it at page 76. And that is also not absolute. That is also qualified by certain circumstances. Page 76, your lordship will kindly see. Unless the governor, in view of the special circumstances of the case, shall otherwise determine. It leaves the power with the governor. After 5 years' continuous absence from this duty elsewhere than on foreign service in India, whether or without leave, a government servant shall be removed from service after following the procedure laid down in Assam Service Discipline and Appeal Rules. It is only an enabling provision, my lord, but still it leaves the discretion available with the governor. Still, it leaves the discretion with the governor because it starts with the words, unless the governor would otherwise determine. And in my case, my lord, the governor had otherwise determined. Governor had allowed me to proceed on voluntary retirement. This FR cannot be applied in respect of a retired employee. It has an application only in case of an employee who is in service. After I have retired, my lord, this way or that way, how can you now, after 11 years, you want to revive this?
Yes, Gogol, what is this?
My lords,
Last occasion also he had considered to the
because
prayer. But
the timeline which has been pointed to by Leonard Senior, my lord, though we at some point of time we are correct, we may be correct, but such a long time has lapsed, and you wake up from the department wakes up from a slumber after a long time. There's no justification to why so much delay was there. That I have to admit.
apparently, my lord, it's a got up case, my lord, in a sense that they want to frustrate, somebody wants to frustrate my claim for pension. Well, otherwise, see, your lordship, from 2012 to November 2012, this order was passed. They were merely silent on this. And FR 54, your lordship, the particular provision which allows the regularization of leave, FR 54, your lordship may kindly see. The order of the governor is also on the point that the leave, whatever, FR 54 I have quoted in paragraph 30, page 24.
When you applied for voluntary retirement, was there disciplinary proceeding pending against you?
There was a disciplinary proceeding pending against you. And the proceeding was unauthorized absence. The charge was of unauthorized absence. Now, 2012 February, I submitted an application that I cannot, because of my illness and other things, I cannot continue with the job. Allow me to proceed on voluntary. Your lordship will kindly see that application, my lord. That the application which I had filed, that is at page 55. 5 or 9 or 9. No, annex 9, page 55. Page 55. Page 55 is the original one, my lord. The type copy was given, has been given later. It is dated 10th of February 2012.
This is
has your lordship found it? Now, after I filed it, next page 57, your lordship will see Page 57, I receive a letter from the department, 17th of April 2012. Has your lordship got it? 17th of April 2012, I receive a letter from the department saying that regarding your prayer for leave and to proceed on voluntary retirement. With reference to the subject cited above, I am directed to request you kindly to submit leave application in the prescribed format for the period of leave which have not been granted so far. You are also requested to apply along with necessary documents for proceeding on voluntary retirement as referred to in your letter dated 10th of February 2012. So 10th of February 2012, I filed an application for voluntary retirement. It is admitted on record. Now thereafter, my lord, the correspondence has ensued and ultimately this order comes. The page 61, 12th November order comes. So therefore, my lord, in all probability, my lord, it had gone into their mind and your lordship will kindly consider the Rule 54 of pension rules, which I have quoted in.
Mr. Datta.
Yes, my lord.
We'll take up some other day. I'll keep it part, huh?
Okay.
Today some problem is. Hurt is Datta, then senior counsel, assisted by.
Then Aditya.
Also had Mr. D. the standing counsel for his department. 13 part. This property hearing on.
26. Director.
When do you want?
And in 29th of February.
Okay. 29.
Obliged.
Item 29.
May I please, the duration IA, my lord.
Mm.
Here the respondent number 2 inadvertently recorded as Director of Health Education, my lord, instead of Director of Medical Education, my lord. That may be correct, my lord. I have filed in one IA for correction, for amendment of the course title. Page number 4, paragraph number 6, my lord. My IA, my lord. It should be Director of Medical Education, my lord.
When is the writ petition coming up?
Hello?
Lordship, it is listed along with the I.
Yes, ma'am.
No.
Last time it was listed on 25/9/2023.
Okay. Heard Mr.
A Boro, my lord.
A. Boro, then the counsel for the applicant. Also heard Mr. P. Upamani. Then the standing counsel.
Health and Family Welfare.
Health and Family Welfare Department. Stop. By this application, the applicant, who is the writ petitioner in WBC number 5548 of 2023, is praying for correction of the address of the respondent number 2, wherein by inadvertence it has been recorded as Director of Health Education, Assam, 6 Mile, Kanabara, Guwahati, 781022, which should have, instead of Director of Medical Education, Assam, 6 Mile, Kanabara, Guwahati, 781022. Stop. After hearing learned counsel for applicant, the prayer for amendment is allowed. Stop. I is disposed. In the main writ petition, you say in view of order passed today in the IA number so and so, let the address of the respondent number 2 be amended as Director of Health Medical Education, Assam, 6 Mile, Khanabara, Guwahati, 781022. Stop. Petition is directed to file an amended application, amended course title within a period of 1 week.
1 week. Yes.
Least after 1 week.
Otherwise, for respondent number 1, 2, 3, my friend is representative, my lord. I have filed.
Lordship,
I have
for
taken
response, the newly corrected respondent, I am
Now
accepting
let him
notice.
find the cost.
Cost,
After that, we'll pass on.
Highly obliged.
31.
In this case, notice had been issued and some one instruction was sought, the directive to be furnished to your lordship as to the status of the appeal, your lordship. Disciplinary appeal, your lordship. In this, what has happened is that I have got the instruction of 2011-23, November, last year, your lordship. There they were saying that the appeal is under consideration, it has not been disposed of. I think your lordship, if your lordship grants me some time, let me get some instructions,
No.
because if the appeal is disposed of, then he may have to amend
I'll
the.
fix the case, madam.
First has to be does, then the counsel for the petitioner. Mr.
CS Hazarika.
CS Hazarika, Leonard, government advocate. Is allowed how much time?
10 days time, your lordship.
It's allowed 2 weeks time to receive instructions.
Kindly fix a date, madam.
List on 6th March.
Obliged.
32.
Your lordship, we need more sometimes, lordship, for further instruction, lordship.
Heard Mr.
Yeah, Mohammed.
A. Mohammed, Leonard, counsel for the petition. MS
J. Bora, lordship, on behalf of
J. Bora, Leonard, counsel appearing on behalf of
S. Dr. Lordship, for responding number 1, 2, 3, and 5.
H. Tata, Leonard, standing counsel.
PNRD, lordship.
PNRD for the respondents 1, 2, 3, and 5. Is allowed how much time?
Lordship, 2 weeks time.
2 weeks time to receive
My lord,
instructions.
They may be directed to file affidavit, my lord. in-
Lordship,
To receive instructions and file affidavit.
Lordship, Date may be fixed. my lord.
11th March.
11 March.
Obliged.
I'm obliged, your lordship.
Item 48 from supplementary list. Forty-eight.
Here, Lordship, I seek 1 week's accommodation, item number 4, because the instructions are still awaited, man.
Okay, heard. None appears for the petition. Mr. P. Nair,
Yes.
Mr. A. Chalia, Leonard, standing counsel. Finance.
Finance Department.
Finance Department is allowed
1 week's time, Lordship.
1 week time to receive instructions. List after 1 week.
34 for orders.
Please, your lordship. Lordship,
Have you taken steps?
My lordship, I was asked to implement the new incumbent, but the present petitioner died, your honor. I have filed the substitution petition today itself, my lord. Completing the legal hairs, man. So after they are substituted, I may be allowed to file the representation.
Mr.
P.S. Raza, my lordship.
P.S. Raja, Leonard, counsel for the petitioner submits that during the pendency of the petition, the petitioner has died. So he also submits that he has filed an IA for substitution. Stop. He'll be filing an IA for substitution of the legal heirs. Stop. Accordingly, list the matter after 1 week.
In the first week of March, man.
List the matter after 2 weeks.
35.
In this matter, my lordship, the petitioner has filed his representation on 3/1/2024.
No, have you taken steps?
Yes, my lordship. He has filed his representation on 3/1/2024. After filing of representation, my lordship, we'll have to wait 3 months as per order of the earlier report, my lord, for compliance. So that's why I'm waiting to file the implementing. Actually, what has happened, my lordship? The petitioner came and he filed his representation on 3/1/2024. It is on January, my lord. We'll have to wait until 3 months, my lord, as per the writ court's order.
There was the incumbent changed office.
Yes, he has changed.
Changed office.
The early incumbent has changed, my lordship. The new incumbent has come in. I had informed the petitioner. Then he came just on January, my lordship. Then he filed his representation on P1
So
2020.
you want to withdraw this?
No, I don't want to withdraw, my lordship. I want to continue, but I need time to file the implement petition.
Okay, on request made by PS Raja, learned counsel for the petitioner. List after 2 weeks.
My lordship, we'll have to wait 3 months, my lordship, because
That's why I'm saying, why don't you just withdraw and after that you can come and file with liberty to file afresh? That is better thing. Otherwise, there'll be an objection from the other side saying that you have filed this content before expiry of 3 months.
my lordship,
You made your representation only on in January this year, isn't it?
my lordship, earlier also we have filed a representation.
But that officer was transferred out,
Yes, my
correct?
lordship.
New officer came in.
Yes, my lordship.
After he came, you made a representation in January.
Yes, my lordship.
So now you have to wait for 3 months.
Yes, my as per writ court order.
As per Rich Court order.
If your lordship will come to page 9 of the contempt petition, my lordship.
So if I allow the impleachment application also,
Oh, my lordship, if your
I would
lordship
say
allows,
if I allow the impleachment application,
if your lordship
then
allows,
then the respondent will come and say, see, I was given 3 months, I got the representation in January. 3 months has not lapsed. Therefore,
if
this-
your lordship allows,
this-
I'll file the implementation tomorrow itself, my lordship.
It's up to you. Then I say on request made by list the matter after 1 week.
Hello.
36.
My please, your lordship. My senior, due to some personal difficulties, he would not appear today. Lordship, matter B can be taken on 21st.
D not. Okay. But Mr.
T. Chakraborty.
Chakraborty,
The date may be fixed, ma'am.
on request made on behalf of Mr. D not, London Council appearing for response number 1. List the matter on 23rd.
Correct. I'm obliged.
37.
In this case, lordship, we need some time to take steps.
You have not taken steps.
We need some time.
Why? Why you didn't take steps?
Non-communication with the petitioner.
From
Yes.
2022.
Sometime.
Mr.
Arsha.
Our counsel for the petitioner prays for 1 week time to take steps for service of notice on the contempt on the respondents 1 and 2 by registered post AD within. Are you sure these officers are holding the office now?
Yes.
By registered post AD. Stop. Praise a lot. List after 4 weeks.
38.
Lordship, kindly see the last order, my lord. They need to apprise the court, my lord.
Yes, Lordship, here we have sent the proposal to the finance department, Lordship, from what I've been informed, since they have not been made a party, that it's under consideration, my lords. Lordship may grant us some time. In the meantime, if the main officer is impleaded also, my lords, because I am appearing for the authorities in the health department, they have already sent the proposal for the petitioner's case, my lords.
So now you have to pressure them, isn't it?
Yes, Lordship, that we have been doing, Lordship, and in 2 weeks to 3 weeks time, as per my oral instruction, Lordship, because I have contacted
Time
office.
may be given, my lord. I cannot implead, my lord. Direction was only to the concerned respondent, my lord, to whom we meet.
Lordship, but at the moment, they are the contemners. The officers in the finance department, with all, like in my humble submission, they are the contemners because we have done our part. The persons who were party to it, they have
Lordship will
already.
see page 27, man, for the moment, my lord.
That I've seen.
Yes,
Direction was given to respond number 1, my lord. He has to act up.
Yes, Lordship, we are sending them reminders. Lordship may grant us some time.
Let him file affidavit, my lord, in that case, my lord.
You file your affidavit.
Lordship, we'll file the affidavit, but the affidavit won't solve the grievance. Lordship,
Whatever action they have taken.
yes, Lordship, that
But
can be done.
Mr. J. Baruel and the counsel for petition. Mr. H. Alial and the learned counsel for the respondents.
Respondent number 1 and 2. Both
1
are,
and 2. Praise for how much time?
3 weeks time, Lordship.
3 weeks time to file an affidavit. Stop. Praise a lot. List after 3 weeks.
My lord, the date may be given ended at 3 weeks, 4 weeks, my lord.
21st
March.
20 March.
20 months. My lord.
39.
Your Lordship, the pension proposal has been submitted to the Accountant General, Lordship, on 12/1/24. So,
where's the order?
Order is Lordship page.
Page 9. 9 to 8.
Matter relates to family pension, Lordship, dispute with two wives, Lordship, between two wives.
In equal proportions. Yes.
We have forwarded the pension proposal to the AG, Lord.
AG is a party here.
AG is not a party here, Lord.
So you take instructions.
Lordship, may pick up at 3 weeks, Lord.
Okay, heard Mr.
J.I. member.
J.
Mandal.
Mandal and counsel for the petition. Mr.
N. Upadhyay.
N. Upadhyay, as learned counsel only, no? Learned counsel.
I mean, as a counsel, Lord, appearing for the both the
Appearing for the respondent 1 and 2 submits that the respondents have sent the proposal to the office of the Accountant General Assam.
Okay.
Stop. He therefore press for some more time to receive further instructions. Praise allowed. List after 2 weeks.
3 weeks, Lord.
3 weeks.
40.
My lord, I request your lordship to look into the order dated 12/1/24.
Today morning, the order has been passed, Your Lordship.
My friend is saying that they have passed an order. Yeah.
Your Lordship, I have already furnished a copy.
Yeah.
Lordship, can I read it?
Yeah. They have rejected my representation, I think.
Yes. If you got a copy of
No, my lord, just now.
The third page, Your Lordship, may kindly peruse.
The contempt is
Closed.
closed. Heard Mr. P.K. Roger and the counsel for the petitioner. MS
N. Bordole.
and Badole, learned counsel appearing for the sole respondent, has furnished an order dated 19/2/2024, issued by the
This is issued by the Principal Secretary, Your Lordship.
Principal Secretary to the Governor of Assam Revenue and DM Department,
Yes.
which wherein The representation dated 11/11/2013 made by the petitioner is rejected. Stop. Para. Considering the order dated 19/2/2024, this court is of the considered opinion that substantial compliance has been made by the respondent, and accordingly, this contempt petition is closed. Order dated 19/2/2024 is placed on the court.
Well,
Deeply obliged.
You have the liberty to check.
well, obliged.
41.
Lordship contempt petition. Order Lordship, kindly have a look at page 11.
Have you filed your additional affidavit?
Lordship, I have filed. Now notice may go, Lordship.
What is it?
Lordship, we have filed an additional affidavit on 30th of January, Lordship. That is, Lordship, kindly have a look at page 18.
Now, when was the order passed?
Lordship, it was passed in the year 2022, Lordship.
What order? 13?
Lordship, operative portion of the order at page 11.
Oh, 1 minute.
13 is the communication.
When did you file your, make your representation?
Lordship, it is in the month of May. Page 13, Lordship.
Page?
13.
Okay, heard Ella Mazumdar, then counsel for the petitioner, issue notice. Petitioner to take steps for service of notice on the sole respondent by registered post ID within 1 week. List after 4 weeks.
Obliged.
42.
May it please, your Lordship. In this matter, Lordship, we have taken the steps, but Lordship, the steps returned as the sole contemner Minal Hazarika is not a Minal Hazarika, it should be Minal Shaikia. So we have to take instruction from the petitioner whether he is Minal Hazarika or Minal Shaikia. So some time may be granted.
Okay, on request made by Mr.
S.R.A. Nasir on behalf of A. Hassan.
S.R.A.
Nasir.
Appearing on behalf of Mr. A. Hassan.
Hassan, Lordship.
List the matter after
2 weeks, Lordship.
43.
Highly obliged.
May it please your Lordship, an IA has been filed for impleading Housing and Finance Department as well as the Housing and Urban Affair and Finance Department in a contempt petition, Lordship. We have filed an additional affidavit where the representation has been annexed, Lordship.
What is this IA?
Lordship, this IA is to implead Housing and Urban Affairs as well as Finance Department in a contempt proceeding. Lordship, a writ petition was.
Can you implead the department in a contempt proceeding?
By name.
It's by name.
By name?
Yes, Lordship.
Where is that?
Jayant Kumar Nalikar, he is the Commissioner Secretary to Government of Finance Department, and Kavita Padmanabhan is the Commissioner Secretary of the Department of Housing and Urban Affairs. He wants to be, my friend wants to implement those two officers
In the
as
contempt.
respondent of 2 and 3.
Yes,
In the
Lordship.
contempt. Were they parties in the writ petition?
Lordship, Finance Department was a party to a writ petition.
And housing?
Housing was not a party in the writ petition. However, the affidavit in opposition filed in the contempt case, the GMDA department has said the order is not being, they are not able to comply with the order because budget has not been allocated from housing and urban.
Okay,
affair.
but MS,
P. Gupta.
well, counsel for the applicant. By this application, the applicant is praying for implementment of Shri Jayant Narlika, page 2, huh? Just put 8A to A. As party respondents, party respondents,
2 and 3.
2 and 3 in condemned case number 358 of 2023. Stop, Mr. S. Bora.
There will be another one, Madam. Kavita Padmanabhan, she will be 3.
Oh, that is as respondent 2 and 3 in the present contempt. You just type out 8. Stop. Mr.
No, I'm as Bora for sole respondent.
Applying for the respond number 1 has no objections. Stop. On perusal of the court shown in the present application, therefore implementation is allowed, I is disposed. In view of the, in the main contempt, in view of the order passed today in IA number so let, then you put the names, huh? Be implemented as party respondents number 2 and
2 and
3
3.
in the present contempt petition. The petitioner is directed to file an amended course title within
1 week, Lordship.
1 week. Stop. Petitioner to take steps for service of notice on the newly implemented respondents 2 and 3 by registered post AD within 1 week from today.
Yes, Lordship.
List after 4 weeks.
Obliged.